All right, I do have 9 on the dot on my state issue computer, so we'll go ahead and get started. For the record, today is Wednesday, December 7th, 2022 at 9 a.m. Central Time. This hearing is being conducted both in person and telephonically using Microsoft Teams and is currently being recorded. If you have any technical difficulties or for some reason get disconnected and are not able to rejoin, please call or email me directly. I'll say my direct phone number line here and my email, and then I'll repeat it so if you have time to write it down. My direct phone line is 615-747-5292, and my email is robin.pope, that's ROBIN.POPE @cot.tn.gov. Once again, my phone number is 615-747-5292. We are present before the Tennessee Assessment Appeals Commission, who've been appointed by the State Board of Equalization to review initial decisions and orders of administrative judges and other related matters. My name is Robin Pope. I currently serve as the Executive Secretary to the State Board of Equalization. I'm designated to sit with the Assessment Appeals Commission as a hearing officer. As a hearing officer, my role is to preside at this hearing, rule on questions of the admissibility of evidence, advise the commission members as to the law of the case, ensure the proceedings are carried out in accordance with law. I do not, however, participate in the deliberations of the commission members. I'm not a decision maker in today's appeal. I'll now make some introductions before explaining the procedure today. During deliberations, Mr. Matthew Childress, to my right, will serve as counsel to the commission. He will assist the commission with questions during deliberations and offer guidance regarding the legal sufficiency of their conclusions. But again, he's not a decision maker. He does not have a vote with the commission. He does not participate in their deliberations or their decision making on today's cases. Matthew, would you mind speaking to the microphone, introducing yourself, making sure that technology is working?
Sure. Good morning, everybody. Nice to see everybody this morning. Matthew Childress here. Happy to help.
I'll now ask our commission members to introduce themselves for the record. And I believe your microphones are turned on, but if not, it is the button right on top. So we'll start with our chair, Mr. Philip Russ.
My name is Phil Russ. Morning.
I'm not sure if we heard that the microphone is there's a little green button and it's on.
I'm Don Osborne.
There you go.
Tim Profit.
Todd Rogers.
Right. As I said, Mr. Phil Russ is currently serving as our chair of the commission. As chair of the Assessment Appeals Commission, Mr. Russ will be our de facto presiding member. The presiding member oversees deliberations and concurs in the final written order. Are you okay being our presiding member today? Okay. All of the appeals to be heard today are to be conducted based upon the record available before the administrative law judge during the prior hearing. This means the Assessment Appeals Commission may affirm the decision of the hearing examiner, remand the case for further proceedings, may reverse the decision or parts of the decision if they find the rights of the petitioner have been prejudiced because the administrative findings, inferences, conclusions, or the decision itself is either 1, in violation of constitutional or statutory provisions, generally meaning did the judge follow and apply the law correctly? 2, made upon unlawful procedure, did the judge not follow some proper procedure or is there some abuse of procedure? 3, arbitrary and capricious or characterized by an abuse of discretion or clearly unwarranted exercise of discretion. A little more self-explanatory, was the decision arbitrary? Or finally, was the decision unsupported by evidence that is both substantial and material in light of the entire record? In determining the substantiality of the evidence in the record, the commission can take into account whatever in the record fairly detracts from its weight, but cannot substitute their judgment for that of the hearing examiner as to the weight of the evidence on questions of fact. Generally speaking, the question here is, was there a basis in the record for the decision of the judge? The commission may not replace their judgment for that of the judge on questions of fact, so factual findings made by the judge cannot be replaced by this commission, but nor are you required to ignore inconsistencies in the record or evidence in the record that may suggest 2 answers, but your job is to decide that that judge made a factual finding based upon evidence that was in the record. So the judge made a factual finding, there is no evidence, that's kind of what you're looking for. Largely for our parties, this means that no new or additional facts, testimony, documents, or other evidence may be presented to the commission. Unless there is an irregularity in procedure that is not shown in the record, as far as I'm aware, no one has pled that today. Generally speaking, for our parties, just in advance notice, what this means is that we're limiting this to argument. So you're supposed to be arguing why you believe the judge's decision was decided correctly or incorrectly. If you are going to recite parts of the record or make references to exhibits or things that were in the record before the administrative law judge, I may ask you to reference specifically which exhibits you are referring to. I have a copy of the physical record we can pull up to disseminate to our commission members. I can also display it on our Teams call on our screens here in the Cordell Hull building. Just keep that in mind as you are making your arguments. A copy of the administrative record was previously presented to the commission members using Microsoft OneDrive, the same way we did to the parties, along with any written arguments submitted by the parties in each case before the commission. I also have with me, like I said, a physical copy of the administrative record for each appeal to be heard. I also have a physical copy of the initial decision and order our commission members are to review, and I will hand those out as we hear each appeal. I will also read a copy of that initial decision order at the beginning of every case. We will proceed generally one case at a time, immediately following the other, taking breaks only as necessary. First, I will call roll of the cases we have docketed for today. If you or your representative are present, please either unmute yourself or stand in the room and acknowledge that we are here. So our case, we only have really, I think, 2 parties, but 3 cases today. In no particular order, we've got 2 appeals on behalf of Jonathan and Jenny Hafner. Is anyone here on behalf of Jonathan or Jenny Hafner?
Yes, Jonathan and Jenny Hafner are present.
I'm here.
And that is with Roane County. And I believe I saw Mr. Lee with Roane County in the back of the room. Mr. Lee, could you stand? Our other appeal we have for today is in regard to East Tennessee Pilots Club with Knox County. Mayor, representative for East Tennessee Pilots Club. Thank you. These proceedings are informal. They're designed to be informal, and board members are allowed to ask questions at any time. I will usually stop and ask specifically if you have questions at the end of each argument. Once we've heard all the arguments, I'll briefly describe the charge, some guiding questions for your deliberations. And then once you enter deliberations, there's to be no more communication between the parties and the panel. If you need to ask additional questions or you have questions from the parties, we can reopen those we can exit deliberations, reopen the record, and you can hear from the party and answer those questions. All right, with that said, we have no particular order for today. Everyone's okay. First, maybe because we've got 2 appeals for the Hafners, we'll start with our 1 appeal for East Tennessee Pilots Club. Okay. Our first appeal this morning is in regard to East Tennessee Pilots Club, a Knox County property. I've got property ID 147-022, tax years 2019, 2020, and 2021. For appeal numbers 124321 and 131219. Initial decision and order, evidenced on page 9, was issued on January 18th, 2022. In order to make sure we're all on the same page, I'm going to read the administrative order. Make sure we're all on the same page. This is an appeal by the East Tennessee Pilots Club, Incorporated, hereinafter taxpayer, Pursuant to Tennessee Code annotated, section 67-5-212, subsection B 2, from the initial determination of classifying the subject property as mixed farm and commercial, taxpayer filed an application for reclassification with the State Board of Equalization, hereinafter State Board, for tax years 2019 on July 29, 2019, for tax year 2020 on July 23, 2020, and by agreement of the parties to this hearing to include tax year 2021. Taxpayer seeks to uphold the prior classification of the subject property as farmland. Knox County Property Assessor's Office has classified the property as mixed commercial and farm for assessment of property taxes. The undersigned administrative judge conducted a hearing on this matter on October 28, 2021, and notes in footnote 1, the hearing originally began on September 2nd, 2021, but had to be suspended during the taxpayer's case presentation, and it was resumed on October 28, 2020. In Knoxville, Tennessee, the taxpayer was represented by his attorney, Charles Taylor III. The Knox County Assessor of Property was represented by an attorney with the Knox County Law Director's Office, Myers Morton. Summary of the evidence. The testimony of the taxpayer's witnesses, Frank and Wilson and Rex Berry, and of Barry Mathis, appraiser for the Knox County Assessor's Office, and the following exhibits. I will note here, okay, I will go ahead and read through it. The taxpayer's exhibits include Exhibit 1, Statement of the Case, Exhibit 2, the Initial Decision Order for tax years 2010-2011, Exhibit 3, Tennessee Code Annotated, Section 67-5-501, Subsection 3, Exhibit 4, Aerial Photographs of the Property, Exhibit 5, Photograph of Plaque detailing beginning on the Pilot Club, Exhibit 6, Copy of Lease Agreement between the taxpayer and the City of Knoxville, Exhibit 7, Taxpayer's Charter of Incorporation, Exhibit 8, the bylaws of the East Tennessee Pilot Club, Exhibit 9, Tennessee Valley Authority, TVA flood map of the subject property, Exhibit 10, electronic mail regarding TVA restrictions, Exhibit 11, photograph of the flooding at the subject property, Exhibit 12, diagram of hangar elevations on the subject property, Exhibit 13, photograph of the clubhouse, Exhibit 14, photographs of the interior of the clubhouse, Exhibit 15, photograph of the back of the clubhouse, Exhibit 16, photograph of the dock on the subject property, Exhibit 17, photograph of a hangar on the subject property, Exhibit 18, photograph of the interior of a hangar, Exhibit 19, photograph of the private hangars on the west side of the subject property, Exhibit 20, photograph of the private hangars on the east side of the subject property, Exhibit 21, photograph of the electrical meters and flood openings for the private hangars, 22, photograph of the flood openings for the private hangars, Exhibit 23, photograph of the lake shore of the subject property, Exhibit 24, photograph of the sign for the subject property, Exhibit 25, photograph of the security gate in the subject property, Exhibit 26, Federal Aviation Administration sectional chart of the subject property, Exhibit 27, photograph of the information board in the clubhouse, Exhibit 28, photograph of an airplane on the subject property, Exhibit 29, photograph of a fuel tank on the subject property, Exhibit 30, photograph of an airplane on the subject property with an uncovered tie down, Exhibit 31, photograph of hangars on the subject property, and Exhibit 32, 2020 financial report for the East Tennessee Pilot Club. The Assessor's Office exhibits included Exhibit 1, the 2019 Knox County Board of Equalization supporting tax documents for the subject property, Exhibit 2, the 2020 Knox County Board of Equalization supporting tax documents for the subject property, Exhibit 3, aerial photographs of the subject property, Exhibit 4, collective photographs of the subject property, Exhibit 5, Google map of the subject property, Exhibit 6, photograph of a sign leading to the subject property, Exhibit 7, the taxpayer's response to discovery, Exhibit 8, notice of a tax lien from 1983, Exhibit 9, East Tennessee Pilot Club brochure, Exhibit 10, 2015 and 2016 tax appraisal cards, Exhibit 11, Knox County data collection card, Exhibit 12, electronic mail regarding TVA restrictions, Exhibit 13, lease agreement between Knox County and the East Tennessee Pilots Club, Exhibit 14, notice of mechanics and materialmen's lien, Exhibit 15, notice of state tax lien, Exhibit 16, warranty deed of subject property, Exhibit 17, deed of trust for the subject property, and Exhibit 18, new service utility easement for the subject property. Findings of fact and conclusions of law. Subject property of this hearing consists of approximately 81.8 acres with only 26.6 acres of the total above water. Subject property located above the water is a private recreational grass landing strip located off Alcoa Highway in Knox County, Tennessee. The subject property is currently being used by a private airplane club, the East Tennessee Pilot Club, hereinafter club. The sole issue of this hearing is whether the subject property should be classified as farm property or a mix of farm property and commercial property. The taxpayers purchased the subject property from the City of Knoxville in 1992. Prior to that, the taxpayers leased the property. Due to the property being located in the Tennessee Valley Authority's, that is the TVA's floodplain, TVA has imposed a number of restrictions on the use of the property, including the following. A, no residential or commercial development of any kind could be placed in the property. B, no enclosed structures, that is having walls, could be placed on the property. C, no sewage or septic systems could be placed on the property. Then on page 4, we have the TVA eventually allowed the club to construct some modified hangars on the property with the requirement that the hangars, quote, open structures without walls, end quote, or designed with grade level openings that allowed the floodwaters to enter and exit. In addition, the club was allowed to build a clubhouse on the property, a paved road, and a maintenance hangar for use by all club members. As the party seeking to change the current assessment of the subject property, the appellant has the burden of proof in this administrative proceeding. State Board Rule 0600-1.11 subsection 1. With respect to classification, Tennessee Code Annotated, section 67-5-501 provides in relevant part as follows. Subsection 3, farm property includes all real property that is used or held for use in agriculture, including, but not limited to, growing crops, pastures, orchards, nurseries, plants, trees, timber, raising livestock or poultry, or the production of raw dairy products, and acreage used for recreational purposes by clubs, including golf course playing hole improvements. 4, industrial and commercial property includes all property of every kind used directly and indirectly or held for use for any commercial, public or private, non-exempt lodge, business, or similar purpose, whether conducted for profit or not. The taxpayer attorney argued that the subject property should remain classified as farm property and that a 2011 decision by the State Board of Equalization ruling the subject property as farm property would still be controlling as that the property as remain essentially unchanged since the decision. You notice in footnote 2, he's talking about in regard to East Tennessee Pilots Club, appeal number 63251, tax years 2010 and 2011. The assessor's office attorney argued that the issue presented in this case were never addressed in the prior decision regarding classification, and that actions taken by the club, as well as improvements done to the subject property by the club, warrant a change in the classification of the property. Testimony of the parties. Taxpayer's first witness was Frank Wilson, who is the president of the East Tennessee Pilots Club. Mr. Wilson testified that there are no residential or commercial buildings on the property, and the club owns 3 buildings consisting of a clubhouse and 2 maintenance hangars. Remaining hangars are owned by individual club members. He would further testify that under the club's charter, it is organized for recreational purposes only, and the club has no employees and no one has no business license. He would also testify that the club collects yearly dues from its members. Members are allowed to use the clubhouse and a boat dock on the property at no charge. With respect to the private hangars on the property, Mr. Wilson testified that members pay the entire cost of the hangar and the member is responsible for construction, insurance, maintenance, utilities, and other costs associated with the hangar. Further, the hangars can only be sold to other members in good standing with the club, he testified. He also testified that prior to building the hangars, the member has to be in good standing with the club and notify the club of their intent to build a hangar in order to receive an assigned space on the property. With respect to club membership, Mr. Wilson testified that all applications must be approved by the club's board of directors. He also testified the club does not offer any type of flight instructions, but individual members who are properly certified can provide lessons and are allowed to advertise lessons on a community board in the clubhouse. The club receives no money from any lessons provided by the members. Mr. Wilson also testified that the club has rental planes for members and the money from the rentals go directly to the cost of maintaining the rental planes. Further, the members are allowed to use a fuel tank on the property and the fuel is provided to the members at cost. He stated that the club receives no profit from the rentals nor fuel provided to the members. He also testified that the only change by the club since the last decision in 2011 was the addition of 1 private hangar. Under cross-examination, Mr. Wilson testified regarding club dues and hangar ownership by members. Mr. Wilson also testified under cross-examination that the club owns 4 airplanes that are used as rentals. Further testified that the hangar owner pays taxes associated with hangar crew fees for the club, and the owner cannot rent their hangars to other members and can only sell their hangars to other club members. Taxpayer's second witness was Rex Berry, who is the club treasurer and has served in that capacity since 1993. He is also responsible for paying all bills of the club. Mr. Berry testified regarding the duties the dues structures of the club and how the dues are used to pay club expenses and property taxes. Further testified that the club has no employees, provides no goods or services to the public, and has no business license, provides fuel to members at cost. Under cross-examination, Mr. Berry testified that the club currently has approximately 185 members. Mr. Berry also testified that the boat dock, which was built by the Boy Scouts, was added since prior decision along with a new hangar and airplanes and can be used by the members at no charge. According to Mr. Berry, any tax increase will be passed down to the members to pay. The assessor's office's witness, Barry Mathis, who is the deputy assessor for Knox County, testified that subject property's split assessment classification was correct under current assessment practices for Knox County. Mr. Mathis testified that based on aerial photos taken of the subject property, that improvements such as hangars and buildings constitute approximately 3 acres of the property and should be assessed at 40%, while the remaining 22 acres should be assessed at 25%. Further testified that split assessments were common when classifying properties such as tree nurseries, golf courses, mobile home parks, ballparks, and boat clubs. He also testified that 2011 decision should not be a factor since each year stands alone. For cross-examination, Mr. Mathis testified that a factor in determining the club's classification was that the club charged additional fees from members that owned hangars. Mr. Mathis testified that 2 or more entities were using the property, thus qualified it as a commercial property. Holding. Based upon the testimony and evidence, it is determined that the assessor's office incorrectly classified the subject property as part commercial property and part farm property. The administrative judge finds that the subject property shall be classified as farm property based on the fact that the taxpayer is a club and that the subject property is used exclusively for recreational purposes. For this reason, I find Tennessee Code Annotated Section 67-5-501 subsection 3 controlling in this matter. The taxpayer is forbidden under restrictions placed on the subject property by TVA from placing any commercial development on the property based on the testimony presented. I find that the taxpayer has maintained their club activities consistent with this restriction. All dues collected go towards maintaining club expenses, and there is no evidence of any profit made by the club. Further, the assessor's office argues that the club providing hangars to members, along with flying lessons, use of rental planes, tie downs for planes, a clubhouse, fuel center, and boat dock is consistent with a commercial enterprise. However, as testified to by the taxpayer's witness, these services are provided by club members for free or at cost with no profit being made by the taxpayer. It is also not disputed that the taxpayer has no business license and has never had one, and there is no evidence indicating that Knox County has ever investigated or alleged the taxpayer has been operating a commercial operation without a license. With respect to the assessor's office's argument regarding the term acreage, I find the assessor's office definition to be narrow and not supported by any statutory language or case law. Like the taxpayer, I cannot find any definition that limits the term only, quote, raw or unimproved land, end quote. Definition notwithstanding, I find that all the subject property is being used for recreational purposes consistent with Tennessee Code Annotated Section 67-5-501 subsection 3. With respect to the assessor's office's argument regarding a landlord-tenant relationship between the club and its members who own a hangar, I find this argument unpersuasive, as there was no testimony or evidence introduced to demonstrate if this is applicable to the current arrangement between the club and its members who own hangars. Respectfully, the taxpayer has met its burden of proof in this matter and demonstrated that the subject property is used exclusively for recreational purposes. Hence, Tennessee Code Annotated Section 67-5-501 subsection 3 controls, and the subject property is classified as farm property. Order. It is therefore ordered that the initial classification of commercial property and farm property for assessment of taxes by the assessor's office be first, and the subject property for assessment of taxes is determined to be entirely farm property for tax years 2019, 2020, and 2021. And concludes on page 8 by setting the available remedies to the parties, including appeal to this body, which is why we are here today. And then on page 9, issued this order on January 18th, 2022, and on the final page, certificate of service noting the decision was sent to the party. As part of today's hearing, We sent a notice of hearing to the parties identifying the administrative record as it was available. That notice of hearing was sent on sorry. Yes, okay, so this matter was previously continued to today's date and a new notice of hearing was then issued on December 7th. On page 2 of that notice of hearing, it said that the administrative record and those documents that were included. As of today, I don't have any notice from the parties that there was any issue with that administrative record.
Correct.
Okay. That, today, I believe, is Knox County, who's appealed the assessment to this, to appeal that decision to the Assessment Appeals Commission. Generally speaking, we will start with you as the petitioner, have you as the taxpayer go, and then I'll have you have a brief. At the time, I'll first briefly ask, do we have any questions before we move on?
I do not.
Remember, looks good to go. All right, so as soon as you're ready.
My name's Myers Morton. I'm a Knox County Deputy Law Director. First thing you need to understand about me, I have hearing loss and I wear hearing aids. And so if I'm talking loud and yelling at you, it's not on purpose. I sometimes in new rooms with new hearing aids I have, I don't know how loud I'm talking. So forgive me in advance. Also, I referenced my appellate brief I filed February 17, 2022 for you all to see and review. And also in the record, taxpayer's lawyer and I, record has a transcript of the testimony. So and I refer to that. Okay. If the court please. Taxpayer is a club. It owns a 26-acre airport, the grass landing strip, and scattered improvements. It's called Sky Ranch. It's on Alcoa Highway from Knoxville going out to the McGee Tyson Airport or toward Maryville. It's in a floodplain. Sky Ranch has, this is the point, the entire point of the appeal. Sky Ranch has both acreage used for purposes by clubs. It has both acreage used for recreational purposes by clubs and structural improvements that were also used for recreational purposes by the club. The structural improvements are many hangars, airport hangars, aprons out in front of the hangars. There's also airplane tie downs. That's like a hangar, but it doesn't have any roof. Some of them have roofs, but it's just a tie down. That's where they park some planes. There's a clubhouse and a fueling station. With the hangars, some hangars are merely 4 poles and a roof, while some other hangars have walls, aprons, and heating and air conditioning, different kinds. Club members are said to own the hangars, and they are entered into like a landlord-tenant type arrangement. They pay extra money for the hangars. They call them dues, but they pay extra money for the right to have the hangar, to use it, to act like you own it, to exclude people. And the one mistake I think Judge Cochran made, and it's might not be entirely important, but testimony is the owners, the members who own their hangars can and do rent it to other members. Some hangars have 2 planes in there. So there's a relationship. The members who are, they call the owners, have the ability to exclude others, and they also can and do rent their hangar that they own to other tenants. That is like a landlord-tenant arrangement. Judge Cochran said that there was no testimony, but it's clearly in the testimony that they can. Tie downs are similar, like similar purpose from TCA 67.55014, which is a definition of industrial and commercial property. Tie downs can be considered or similar purpose like the hangars. Clubhouse is one of 3 buildings, including 2 maintenance hangars the club uses. There's also a fuel depot and that allows the members to use fuel. The club has what they call, their terminology, a rental fleet. They own 4 planes. And they allow members to use the plane for cost. They sell the gas for cost. They don't profit, but as I'm going to point out later, profit's irrelevant in considering classification. Profit, the statute specifically says profit's not to be considered. I'll get to that, but with the one thing with the rental fleet, members can use it. Also, members who are flight instructors who do not own these planes are allowed to use these planes and give flying lessons to other members. And the arrangements for paying for those flying lessons are between the student member and the teacher, the flight instructor, who is also a member most of the time, I believe. What's odd about the rental fleet is, and there's testimony in the record, the club benefits from a tax exemption that allows them to avoid paying sales and use taxes on these planes that only applies in a commercial setting. It's TCA 676-329A. And I'll be brief. It's the sale at retail, the use, the consumption, the distribution, and the storage for use and consumption in this state of the following tangible personal property is specifically exempted from the tax imposed by this chapter. In paragraph 17, something exempted says aircraft used for and owned by the person providing the flight training. The flight trainer does not own the plane, but they're still taking advantage and proceeding as if the flight director owns it and not the club. So I suggested to the judge, and I suggest to this board, there ought to be some estoppel there. They can't say we're not commercial at the same time benefit from an exemption. And that's in the record, if the court please. The club owns the planes, and the person providing the flight training does not own the planes. Okay. So what the property assessor did is we had these improvements, the hangars, the tie downs, the clubhouse, the maintenance hangar, and rounded down. He rounded down to 3 acres. These improvements sit on 3 of the 26 acres. So 3 of the acres were assessed, classified as commercial and industrial. And the remaining 23 acres are unimproved. It's raw land. It includes a landing strip that's grass, it's level, but there's no other improvements on the rest of it. So it's a split assessment where 3 acres are assessed at 40% as industrial, commercial, and the remaining 23 is farmland. I don't think the last go around and I think counsel for the taxpayer is going to try to take the position this has already been decided previously by Judge Minsky, saying all of it is be farmland. And there's some cases I've cited in my brief where Judge Minsky's case is referred to and it's pointed out by Judge subsequent judges that that case did not deal with split classification. This situation is the first time that we've had a split classification. And the law, starting with the Constitution, the Tennessee requires, allows for split for subclasses. It's synonymous, I understand. Split classification, subclassification are synonymous. Article 2, Section 28 of the Tennessee Constitution talks about class or subclasses being required to being allowed to be done. The legislature and its statutes call for allow property assessors to have subclassifications of property, depending on how they're used. TCA section 675801B requires subclassifications where a parcel of real property is used for more than one purpose, which result in different subclassifications and different assessment percentages. Then it shall be apportioned among subclasses according to guidelines established by rules and regulations of the State Board of Equalization. Well, the State Board of Equalization has those rules. 0600-12-.04 gives examples or analogies of when you would subclass. Multiple use subclassification is what it's called. One is a home business run out of someone's residence. Carry on a trade or business like a beauty salon or a daycare. That's an analogy and an example of subclassification. A mobile home park. You've got common area and you've got people on-site privately owned mobile homes. That's from the Board of Equalization rules. Those are, and it says these are only examples and do not represent all situations where multiple use subclassifications is appropriate. Another rule of the board is 600-12-.07 titled Examples of Apportioning Among Subclasses. And it goes to mobile home parks, among other things. So you've got a 26-acre tract with raw land. There are improvements that cover, rounding down, 3 acres. I respectfully contend that the administrative law judge made some errors that were prejudicial. He did not recognize and did not understand what acreage meant, what acreage was. I'm looking, I have a note where his decision was, read that. You've already, court did not understand the term acreage. So I'm going to read the definition of farm property, TCA 6755013. Farm property includes all real property that is used or held for use in agriculture, including but not limited to growing crops, pastures, orchards, nurseries, plants, trees, timber, raising livestock or poultry, or the production of raw products. And this is the definition of farm property, and acreage used for recreational purposes by clubs. They didn't, one of these cases that I've cited here, and I'll go over in a minute, point out the definition of farm property says acreage used for recreational purpose by clubs. It doesn't say real property used by clubs, and there's a definition of real property. It's the same, it's 675501 10A. Real property includes land, tenements or ediments, structures and improvements. Real property includes structures and improvements. Acreage doesn't. And so farm property is defined as including acreage, and acreage, as in these cases, is undeveloped. There's attached to one of the cases we have in the Badgett, one of the Badgett cases is there in my brief, there's attached a, Tennessee Attorney General opinion as Exhibit A to that opinion, where where I'm analogizing, but where the property is unimproved. If there's an improvement, if it's got a structure, if it's been improved, it's real property. Acreage is unimproved property. And the definition of farm property includes acreage used for recreational purposes by clubs. Then in the Armona Land Corporation case, it's in my brief. I quote the decision that, quote, acreage, end quote, was meant to limit the type of real property classable as farm property used by recreational purposes by clubs to land only. Any improvement which is customarily assessed separately from the land should not be considered acreage. According must fall instead with the definition of industrial and commercial property, which includes property of every kind used directly or indirectly or held or used for any club purpose. And I'll point out that that definition of industrial commercial property has the word club in it. Industrial and commercial property, which is says to 40%, includes all property of every kind used directly or indirectly or held for use or any commercial, mining, industrial, manufacturing, trade, profession, club, whether public or private. Skip a little bit, whether conducted for profit or not. So my point being, if the court please, the definition of farm property only covers club acreage. And acreage is undeveloped, unimproved property. The farm property, the commercial and industrial definition also anticipates club property, real property, and real properties. I hope I'm not being repetitive. Forgive me, man, but real properties defined in this same statute, 10A, is including structures and improvements. The court administrative law judge seemed to believe this was not commercial property because they made no profit. Read the definitions, profit's irrelevant. It's how it's held, what it's capable of. And we've got a situation with these hangars where members pay extra to have it and they can rent it to anybody, any other member. And they do. There's more than two planes in there at a time. So profit, I think I respectfully suggest profit's not a factor to be considered when you have split classifications. And then we have the hangar landlord relationship that I've been talking about. In some of these other cases, we analogize like ballparks. There's one of these cases talks with a boat club, the raw, undisturbed, undeveloped land is acreage. And it's developed, has structures, that's industrial and commercial. And to the extent it matters, there's some mistakes, some errors, but I'm not so sure they're prejudicial. For instance, in the record, the taxpayer put in the record all the TVA restrictions. It's in the record on all the restrictions on this property, and there's not one restriction on commercial property. There's no restrictions on commercial property in this record. In this record, in the documents, the only restriction, the only time that it says there's a commercial restriction is Judge Minsky's decision. But I don't know that that's a prejudicial error because profit shouldn't matter. Okay, so I don't know that the fact that, but that's a mistake that I think the judge made, that there is no commercial restrictions in this. But, and the whole point is we're trying to make this simply is on the definitions. What farm property is. Farm property is acreage used for recreational purposes. Acreage under the case law, under the analogies. All these cases say acreage is developed property. Developed property has to be, structures are typically, commonly classified as industrial and commercial. If I have an opportunity to
So usually at this time I ask if the commission has any questions this time.
Mr. Rogers.
Not at this time.
I don't have any at this time.
I don't have any.
As soon as you guys are ready, you guys.
Is this on?
Yep.
Would you gentlemen mind if I stood so I could refer to my posters over there?
So you should be able to,
Yeah, there you
yep,
go.
got it.
I'm gonna put this chair around there to set them in.
pardon me, may I at times walk over here and look at the.
Sure. Yep, go for it, yeah. It's all informal here. Yeah.
Thank you. First of all, these posters are enlargements of exhibits that are already in the administrative record. There's nothing new here, and if you need me to refer to the exhibit number, I'll be glad to. My name's Charles Taylor. I'm the attorney for the taxpayer, the appellee in this case, East Tennessee Pilots Club. In order to understand what this case is all about, I need to give you a little background about the club. The club owns a piece of property, as you've already heard. It's a grass landing strip, a little island, Tennessee River, Knox County, called the Sky Ranch. It's about 26 acres. Originally, it was 82 acres. We'll talk about that in just a second. The Sky Ranch has been in use since the 1930s. Back in the 1930s, when aviation was starting to get popular, some local pilots in Knoxville wanted a place to fly in and out of. There was this, like I said, 82-acre farm there along the Tennessee River, and they contacted the farmer and they asked permission to land and take off there, and the farmer gave them permission. They were probably half a dozen pilots at the most. They didn't have any hangars. They were not organized into a club or any kind of organization. Just pilots out there want to have a good time. That continued for about 10 years. And then in 1940s, two things happened that affected the Sky Ranch and the pilots. First was World War II. Following World War II, a lot of military pilots who had been trained and fought in the war came home, came back to Knoxville. They wanted to continue to fly. So they got together and started again using the Sky Ranch, that farmer's 82 acres. They formed a club. It was an informal club. It wasn't incorporated. At that time, they started allowing members to build some hangars there to keep their airplanes in. That continued on. It grew until where it is now. Eventually, the pilots bought the Sky Ranch. They formed a nonprofit corporation, and it's in existence today, just like I talked about earlier. Just like Judge Cochran found in his findings of fact, doesn't have a business license. It doesn't have any employees, never has had any employees, doesn't sell anything to the public, doesn't offer any services to the public. The airport can only be used by members. In fact, if we were to look at this is an aeronautical chart. If you were to look on an aeronautical chart of that area, you'd see, I'm sure it's hard to see from back there, but the little blue and white, that's the commercial airport, McGee Tyson Airport in Knoxville. Right up here at the top, there's a little circle with an R in it. Well, that's the Sky Ranch. The reason it's got an R in it because it's restricted. The public can't land there except in an emergency. Not open to anybody to come there and land, only members. We do have a clubhouse. We have a maintenance building where people can work on the airplanes. Club does not provide any instruction. If the members want to take flying lessons, they can contact an instructor on their own, pay for it on their own. None of that goes through the club. The club doesn't handle any money. Same with maintenance. If you want to work on your airplane, you can do that. If you want to go take it somewhere or hire someone to work on it, you can do that, but that has nothing to do with the club. We do have a fuel tank there that club members can get gas out of, and they're charged cost, exactly what it costs the club. Whatsoever. Club membership, as you've heard, consists of a lot of different types of pilots. Many, like myself, are former military pilots. I joined the club in 2007 after I retired from the Army. I had flown Army helicopters for 25 years. We all also have retired commercial pilots, a lot of general aviation pilots. We even have people out there that don't fly at all. They don't have a pilot's license. They like to be around airplanes. We have a lot of members. As I said, since 1930, that's the way it's existed. Nothing else has changed. During that, back up a second, I said a few minutes ago, two things happened in the 1940s that affected the club. First was World War II. Second was TVA, Tennessee Valley Authority. Like I said, originally, that was an 82-acre farm. TVA came along and started building dams. Built one called Loudon Dam, just below this. It flooded this whole area, and that became Fort Loudon Lake. As a result of that 82 acres, most of it went underwater. Only 26 acres now still remain above water, and the rest is at the bottom of Fort Loudon Lake. Not only did they flood most of the farm, but all of this area is now floodplain, TVA floodplain. This is a TVA map. Difficult to see, but the areas that are dark blue are TVA floodplains. This is the Sky Ranch. This whole island is in the TVA floodplain, except for one tiny little white bit right here at the end, and that's where our clubhouse is. Only dry land can put a structure. And it does flood about once every 3 or 4 years. Water comes up and it floods. This was made a few years ago. You can see the whole runway is covered with water. All the airplanes had to be moved back to higher ground to stay out of the floodplain. Because it is in the floodplain, TVA has imposed certain restrictions we have to follow. I've listed some of these, and again, this is in Judge Cochran's findings of fact. He found that these restrictions existed. Number one, no residential or commercial development of any kind can be placed on the property. No houses, nothing commercial, nothing. Number two, no enclosed structures having walls can be placed on the property. Number three, no sewage or septic systems can be placed on the property. B here, the second one, no enclosed hangars. That's the reason all of our hangars there are either open, no walls at all, or they're required to have flood doors. Or I don't know what the official name is, but this is a hangar, and you can see all of these doors along through here. Those are openings that the TVA requires. So if it does flood, the water won't get trapped inside and can come out. Because of these restrictions, because of how the property is used, since 1930, when this first started, Knox County Property Assessor has classified us as farm property. That was how it was being used, and that's how it continued. 1973, state legislature actually codified this use. They enacted a statute, TCA 67501, which we've already talked about, which says farm property includes any acreage used for recreational purposes by clubs. That became Tennessee law, and since 1973 until 2010, Knox County Property Assessor followed that law. Because we were a club using this property for recreational purposes only, they classified us as farm property. Then in 2010, something happened. I don't know. I don't know if anybody knows why, but the Knox County Property Assessor decided He was going to change that farm classification, classified all of the Sky Ranch, all 26 acres, as commercial. We, of course, appealed it. Ended up going in front of an administrative judge from the State Board of Equalization, Judge Mark Minsky. In October of 2011, we had the trial all day. We had witnesses from the taxpayer side. We had witnesses from the Knox County Property Assessor. Briefs were filed. At the end, Judge Minsky took it under consideration, and later he issued a written opinion, a very detailed written opinion in which he said, Club has no employees, is engaged in no business, provides no products or services to the public. Administrative judge finds there is no dispute that the appellant constitutes a club within the meaning of the statute. Administrative judge finds the appellant established that subject property is used exclusively for recreational purposes. Hence, subsection 3 controls subject property must be classified as farm property. That was for 2011. Knox County Property Assessor followed that ruling for 3 years, and then in 2013, they decided to ignore it. Come back, and now they classify part of the Sky Ranch as commercial, part of it as resident or as farm. Mr. Morton indicated that only 3 acres are being classified as commercial, and the rest is being classified as farm. What he failed to mention, though, is that the part that they're classifying as commercial is 90% of the value of the property. Runway, which may have more acreage, is only 10% of the value. So basically, we're being taxed at 40% assessment for 90% of the value of the property, and only 10% gets the farm assessment. So it's a little misleading there to say, well, we're only classifying 3 acres. It's 90% of the value of the property. In any event, after the property assessor did that, we appealed it once more. It ended up being an appeal for 3 years just because of the delay in getting a hearing. Last fall, we go before another administrative judge from the State Board of Equalization, Judge Jerome Cochran. Again, we had a long trial, took 2 days this time. Lots of witnesses were put on both sides. I put on witnesses from the taxpayer side. Morton put on witnesses from the property assessor side. We filed briefs. Each of us, I think, filed 2 briefs. Judge Cochran took it under advisement, and weeks later, he issued findings, which I hope is already read to you, but basically, and this is just a summary of it, Club has no employee, excuse me, wrong one. Minsky, this is Judge Cochran. Based upon the testimony and evidence, it is determined that the assessor's office incorrectly classified the subject property as part commercial property and part farm. Administrative judge finds, finding of fact, subject property shall be classified as farm property based on the fact that the taxpayer is a club and that the subject property is used exclusively for recreational purposes. For this reason, I find Tennessee Code annotated 67.5.501.3 controlling this matter. Here we've got 2 administrative judges hearing same facts 10 years apart. Now, also, as you point out, as Mr. Pope pointed out a few minutes ago, at the hearing, the second hearing, it was undisputed that nothing had changed in that 10 years except there was 1 more additional hangar that it, nothing else had changed. Employees still did not involve any commercial activity. So that's where we are today. In regard to some of the arguments that Mr. Morton talked about, Judge Cochran addressed those, and I don't want to go over them, but this idea that, well, you're entitled to the exemption only if you have acreage, and acreage doesn't include improvements, there's no law to that effect. All of the cases in Tennessee, and these were provided to you in the briefs we filed, the courts use the terms land, acreage, real estate, property. They're all interchangeable, all mean the same. That's why acreage, as used in that exemption, it doesn't apply just to unimproved property or raw property. And there's no law to that effect, and there's no cases holding that. In terms of the argument made by the Knox County Property Assessor, well, this is like a landlord-tenant relationship. Those, the hangar owners, they're paying dues. That's a landlord-tenant. Well, The statute that they relied on at the hearing talks about dwelling units where people live. None of this doesn't apply at all in this case. Every argument that you heard here today was made in front of Judge Cochran, and he addressed it in his order. He just found it didn't apply. So in summary, I looked at the statute that says exactly what Appeals Commission scope of review is, and Mr. Hope read that to you a minute ago. I'm not going to go over it, but it talks about the things that you can reverse a decision of the administrative judge only if you find it's in violation of constitutional, statutory provision, unlawful, et cetera, et cetera. Key point is down here at the bottom, which I put in, which I've highlighted. That says the Assessment Appeals Commission shall not substitute its judgment, that of the hearing examiner, as to the weight of the evidence on questions of fact. All respect, that's what the county property assessor wants you to do today. They're wanting you to come in and saying that these two administrative judges spent hours of working on these cases and reviewing the briefs, hearing the testimony, and then came to findings of fact that you've heard and conclusions of law that you ought to substitute your judgment for theirs, throw out everything that they did. I respectfully submit, gentlemen, that's not what the law says. They're entitled to be respected for what they did. We're asking that you uphold what Judge Cochran ruled. I'll be glad to answer any questions. Thank you.
So, yeah.
I don't have any questions.
I do have a couple. There seem to be some discrepancy. Excuse me. There seemed to be some discrepancy in reading what Judge Cochran wrote about the hangars, that they could only rent the hangars to plane members, but as I understood it, that was one you couldn't own and rent. In other words, there are two planes in there. How does that work under what's been in the record?
You are correct. The rules are that if you build a hangar, of course, you build it at your own expense. The club has nothing to do with it. You're in charge of it. If you want to sell it, you can only sell to another club member. I think the question came up, is it possible that one member could rent space from another? And I think the testimony was it's not prohibited, but as far as we know, that doesn't exist. I think that's in the record, that as far as we know, no club member is renting, but it's not in the bylaws that they couldn't, as long as it's to another club member.
And I had one other on the instructional flights,
Right.
where the student is paying the instructor for the instruction. Is anyone paying for the airplane?
Yes. First of all, a student cannot use someone outside the club as an instructor. If you want to take lessons, you have to use a member who is a qualified flight instructor. So the student would be paying for the airplane, and then whatever deal he made with the instructor, that would be on the outside. I should also point out that under the bylaw club, the members own the airplanes. All of the aircraft are owned by the members. So, you know, the argument that was made a few minutes ago, well, you're using an outside instructor, isn't the case. All owners of the airplane.
Thank you.
The student is also a member of the club.
Exactly. No one can fly the airplanes, whether as a member, student, instructor, or as a student or instructor, unless they're a member. Stay on the airplane. And that's one reason we did that, is because of insurance. You know, we insure the plane, so we want to make sure that owners are flying the airplanes.
No other questions? Then we can, make a brief reply.
To make clear in this record, there are 4 planes in the rental fleet that the club owns, that they are taking advantage of a tax exemption that only is supposed to be used by an instructor who owns the plane. They are not the instructor. It's not consistent, okay? Now, as far as Judge Minsky's decision, I mean, my argument is simple as reading reading a couple of these cases in Badgett, Stephen Badgett et al., appeal number 87914, which is in my brief. In East Tennessee Pilots Club, an administrative judge, he's talking about, this is about Judge Minsky. An administrative judge found that an aircraft landing strip used by recreational pilot club exclusively for non-commercial recreational piloting purposes qualified for farm property classification under subsection 3. I paraphrase. In the undersigned administrative judge's opinion, East Tennessee Pilots Club, Inc. simply stands for the proposition that, quote, farm property, end quote, can include acreage used by recreational clubs for recreational purposes, including but not limited to golf. It does, and I'm advancing it. It does not appear the parties or the administrative judge in that case he keeps talking about, in that case, addressed or analyzed the specific issue of subclassification of the hangar improvements. That's what this case is, apples and oranges from that. This is subclassification. That's the whole loss. That's just what this whole thing's about, is subclassification of property being used differently. And then there absolutely is definition of acreage in this case law. I'm going to read from the Armona Land Corp case. It's in my brief. Tennessee Code annotates 76.55019 defines real property to include, quote, improvements, end quote. But in defining, quote, farm property, end quote, the law states not that real property used by clubs for recreational purposes shall be included as farm property, but that acreage used for such purposes shall be farm property. We should assume this distinction was intentional on part of the legislature, and we concur with the assessor's view that acreage was meant to limit the type of real property classifiable as farm property used for recreational purposes by clubs to land only. And as I mentioned earlier, there's an attorney general opinion attached to one of the Badgett cases. It talks about unimproved land. So, court, please, point is, this is a subclassification. It didn't happen before. That's what they're trying to do. And according to the state law, according to the board rules, we're doing what we're required to do, to have subclassification. And thank you very much for your time.
Generally conclude our arguments. So it looks like we're ready to have any more questions before we officially enter. Later review, Mr. Russ, we'll enter deliberations. So this time there'll be no more communication between the parties and the commission members. Commission members, if you do have any legal questions or things like that, you can always consult with your counsel, Mr. Matthew Childress. But other than that,
Okay, I think a lot of this is semantic. Is all of my education, real property is land and improvement. Talk about something that's acreage, it can be land, it can be, that's real mechanical and doesn't really apply to what's going on. The question, I think, is should these hangars and the clubhouse, should they be classified as commercial? Reading everything that's going on with that club and what's been going on, there's no profit, there's no employees, there's no sales tax, there's no business license. I mean, we can certainly discuss it, but from my opinion, I think the administrative law judge's decision would hold. Let's go down the line and
Certainly an issue that mixed use. Limits that various extremes. This is a situation where any sale. Have a concern classifying approved structures not used in a farming and get classification issue, testimony and decisions made administrative law judge. What the issues are. So, for that reason, certainly understand the situation having split use. That's not unusual. Bed and breakfast, you know, have an owner that lives at residence and is using part of it for breakfast, commercial activity in it. Based upon the evidence that is.
Mr. Prophet?
Well, as a farm production, they actually sell. This tax exempt club, they don't sell anything. Recreation things, it's made pretty clear. Seems like there's not clear to
Mr. Rogers?
Excuse me. What Phil had mentioned about the distinction between assessment of that real property and Phil, I do see persuasive arguments. This is here. Definitions, statutes here. Will say that, you know, clearly states in the farm for recreational purposes, which basically is what this is, in my opinion. It's based on the fact it's heard justification to substitute our
Could I have a motion to that? Anyone?
make a motion.
Second. Okay, Mr. Osborne, second. All those in favor, please say aye. Aye. Any opposed? Thank you.
Have it, you'll receive a final written copy of this decision within the next 90 days. That decision will identify any further appeal remedies as well. This hearing will be posted on our website and within business days. If you want to get a transcript. Okay, with that, do we need a short break at all before we go? Yeah, okay, we're gonna take a short break. We'll come back at 10:30. We're gonna keep this on the line. So just FYI, I'm not gonna dislodge the recording just in case we have any issues getting it back started. come back at 10. Okay, I have 10:30 on the dot, so we'll go ahead and get back on. I'm going to hand out a copy. I think start with 132015. That is the property ID at map 028, parcel 1302. So as noted on a so there's two parcels under appeal here, but we've got different decisions to review. I'm just trying to be clear which one we're doing as the administrative records were different for the got one parcel that has a $0 improvement value from the local. Got two appeal numbers, 132015. It's the one that has $0 improvement value from the local. We have the other appeal number, 1326, has a $523 million value. Best to make sure which one we're talking about. We're going to start with the unimproved parcel. That is number 132015. So I'm going to hand out a copy of that decision. And as I do that, I was going to say, I guess, Mr. and Mrs. Hafner, want to introduce yourselves to the panel on the phone. We can make sure we can hear and see you, or hear you at least. I know you're joining me via telephone.
I'm Jonathan Hafner. Robin, there was, during the previous appeal, we could hear the two councils very clearly. But once we got to the commission and just now with you, there was a lot of breaking out. And we're having a hard time really hearing almost anything the commission said.
Okay, thank you for that. Can you hear me fine right now? Mr. Hafner, hear me fine right now?
Yeah. You're breaking in and out on me. Mr. Pope.
Okay, I'm not really sure how else to facilitate that. I know the Teams call is working. I don't know if you want to join via a different connection. It might be the phone carrier. We're going to ask our commission members to speak more into the microphone. I do have my computer has access to the audio recording, and I can hear my own voice coming through pretty clearly on that Teams call. So I'm not sure how else to facilitate that, Mr. Hafner.
We can
If it
hear
does
you
become
now.
Yeah.
Okay.
Yeah, now you're coming
I
through
will just-
clearly.
Okay, I will ask our commission members that when you're speaking from the microphone, I know it's a little awkward speaking from a microphone, but do get pretty close to it. You can see how close I am to it. It's relatively right on my face. It does help facilitate the pickup of that.
Yeah.
Okay, with that said, so we have Mr. and Mrs. Hafner on the phone. I'm going to ask the county's council to introduce themselves.
Thank you, Mr. Pope. Robert Lee, appearing on behalf of Roane County Assessor of Property today. I do have a procedural question. Will both Mr. and Ms. Hefner be arguing this, or will just one be designated as the person to make the argument?
So, I don't know. So Mr. and Mrs. Hafner, will both of you be speaking on behalf of the appeal today, or will one of you be largely speaking only?
It'll be largely myself, Jonathan Hafner, speaking.
Okay.
Thank you.
All right, again, we're starting with that unimproved parcel. I have the case caption as in regard to Jonathan and Jenny Hafner, Roane County. Again, that parcel property ID is 028-01302-000. Tax year 2020 and 2021. Appeal number 132015. I have the initial decision in order, and beginning with a statement of the case. The Rome County Board of Equalization, hereinafter the local board, has valued the subject property for tax purposes as follows. Land value of $601,400, an improvement value of $0, a total value of $601,400, or an assessment of $150,350. The taxpayer filed an appeal with the State Board of Equalization, hereinafter State Board, on August 16th, 2020. The taxpayers are further requesting to amend their appeal to include tax years 2021. The undersigned administrative judge conducted a hearing on this matter on December 7th, 2021 in Kingston, Roane County, Tennessee. The appellants, Jonathan and Jenny Hafner, represented themselves at the hearing, hereinafter the taxpayers. The Roane County Assessor of Property was represented by its attorney, Robert Lee, hereinafter the Assessor's Office. Summary of the evidence. The taxpayers testified on their own behalf, and the Assessor's Office witnesses included Molly Hardup, the Assessor of Property for Roane County. The following exhibits were introduced. Exhibit 1, the taxpayer's letter to the State Board of Equalization. Exhibit 2, the taxpayer's comparable property. Exhibit 3, the Lancer Road comparable properties. Exhibit 4, the taxpayer's comparable sales. Exhibit 5, the subject property parcel map. Exhibit 6, aerial map of the subject property. Exhibit 7, usable area map of the subject property. Exhibit 8, the change of assessment notice for the subject property. Exhibit 9, photos of the subject property. And Exhibit 10, the Assessor's Office's valuation analysis. Findings of fact and conclusions of law. The subject property in this appeal consists of a vacant lot containing approximately 8.58 acres in Harriman, Tennessee. The taxpayers contended that the subject property should be valued at $85,800. The Assessor's Office requested that the local board's decision of $601,400 for the subject property's valuation be modified to $556,800 based on a valuation analysis performed by the Assessor's Office. The basis of valuation set out in Tennessee Code Annotated Section 67-5-601, subsection A, is that the value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values. As the party seeking to change the current assessment of the subject property, the appellant has the burden of proof in this administrative proceeding. State Board Rule 0600-1-.11, subsection 1. At the hearing, the taxpayer, Jonathan Hafner, testified that the subject property was purchased with an adjoining lot. And at footnote 1, he notes that the property is also under appeal, and it is case number 132016. Dr. Hafner further testified regarding the previous value placed of the subject property placed on it by an administrative judge in 2015 of $153,000, and why he believed that the subject property's value has decreased since the last evaluation. Dr. Hafner based his contended value on the price per acre of $10,000 per acre as determined in the 2015 decision by the presiding administrative law judge. He also testified that adjacent properties to the subject property are declining in value based on property assessments. The taxpayer, Jenny Hafner, testified regarding the topography of the subject property. According to her testimony, the subject property slopes and is heavily wooded and has cove front and not waterfront since it is not on the main channel. She further testified that she didn't think it was possible to place a boat dock on the subject property. The Assessor's Office's witness, Molly Hardup, the Assessor of Property for Roane County, testified that based on her analysis of the subject property using a front feet analysis, that the subject property's value was $556,800. She further testified that her analysis was based on market sales and price per linear foot along the lake. Under cross-examination, Ms. Hardup testified that with respect to her comparable properties, she wasn't sure the properties had septic systems were in a subdivision or if they had a boat dock. She also testified that no location adjustments was done for her comparable properties. Based on a review of the testimony and evidence, the taxpayer's contended valuation is inadequate and not supported by the evidence. Further, the appraisal report provided by the assessor's office is also inadequate and not reliable in the fact that no location adjustments were made with respect to the subject property. The assessor's office's use of sale prices of nearby properties is not a reliable indicator of property values, as the values they rely on fail to make adjustments in values when compared to the subject property. Factors such as location, square footage, etc. were not taken into account in the comparable sales listed in their valuation analysis. So these comparable sales are not a reliable indicator of what the land values are compared to the subject property. The Assessment Appeals Commission has said that for comparable sales to be relevant, they must be properly adjusted. In E.B. Kissel Jr., Shelby County Tax Years 1991 and 1992, the Commission said the best evidence of the present value of a residential property is generally sales of properties comparable to the subject, comparable in features relevant to value. Perfect comparability is not required, but relevant differences should be explained and accounted for by reasonable adjustments. If evidence of a sale is presented without the required analysis of comparability, it is difficult or impossible for us to use the sale as an indicator of value. Final decision order at 2. Further, the taxpayer's comparable properties are not vacant and containing houses, so the comparisons with the subject property are simply not reliable. Additionally, the taxpayer's reliance on a 6-year-old decision to support their contended value is not reliable. Each tax year stands on its own, and prior tax year values has no influence on property that is valuated in a new tax year. The taxpayer's argument regarding the values of adjacent properties declining while the taxpayer's property increased is also not a reliable argument. The taxpayers testified that the assessed values of their property had increased at a higher rate than another nearby property. However, the Assessment Appeals Commission has repeatedly rejected arguments based on the amount by which an appraisal has increased as a consequence of reappraisal. For example, the Commission rejected such an argument in E.B. Kissel Jr., Shelby County Tax Years 1991 and 1992, reasoning in pertinent part as follows. The rate of increase in the assessment of the subject property since the last reappraisal, or even last year, may be alarming, but is not evidence the value is wrong. It is conceivable that values may change dramatically for some properties, even over so short a time as a year. Final decision order at 2. The assessor's office's valuation analysis using front feet valuation is not reliable due to the fact that no location adjustments were made. The comparable properties vary in size from 14.9 acres to 2.2 acres and further. There is no analysis on if the property frontage is sloped, rocky, or even usable at all. I am also concerned that comparable number 1 of the assessor's office's analysis contains a house on the property, which was also not adjusted. Both parties agree that the local board's valuation of the subject property is excessive, so I am inclined to grant a reduction. Based on the topography of the subject property as described by the taxpayer, I believe a 20% topography reduction is warranted. Respectfully, the evidence introduced by the taxpayer is inadequate and cannot be relied on in this matter. Having failed to carry their burden of proof in this matter, the local board's valuation is modified. It is therefore ordered that the following values be adopted for tax years 2020 and 2021. A land value of $481,120, an improvement value of $0, for a total value of $481,120, and an assessment of $121,280. It then continues on page 5 to the top of page 6 with the appeal remedies, including appeal to this body, which is why we are here today. You then entered this order on February 1st, 2022, and then the order concludes on page 7 with a certificate of service noting it was sent to the parties on the same day. This hearing was originally scheduled in October and then continued to today's date. Accordingly, we resent a notice of hearing on November 3rd, 2022, And on page 2 of that notice of hearing, we identified the administrative record for this body and the administrative record before the Assessment Appeals Commission. To date, no one has had any conflict with that administrative record, and I want to confirm there's no conflict with that administrative record as of today, and there's no concern about it. So Mr. and Mrs. Hafner, do you have any concern about the existing administrative record?
No.
What do you mean by administrative record?
So as I said previously to today's hearings, we are not hearing any evidence or testimony today. Our hearing today is limited to oral arguments about why you believe the administrative judge's decision was decided correctly or incorrectly. The commission cannot reweigh the evidence and find facts different than that of the administrative law judge. So we will not, and we also will not accept any evidence on questions of fact. So with that said, the administrative record shows all the exhibits and the record that was before the administrative law judge at the time. If you want to reference facts and exhibits, I may ask you to specifically reference which exhibits in the record you are discussing. So with that, we previously sent a copy of the administrative record to you and Mr. Lee and the commission members before this hearing. And as of today, I have not received any notice that there's been any issue with that administrative record. So I just want to confirm before we begin that there's no issues with that administrative record.
The only document I cannot find is an appraisal report from Creighton Cross. That's the one the administrative judge referenced that said it had a house on it. And I just can't find it here, and you may be able to help me. But I'm logged in and I just don't see it here. And that's the one referenced to by Judge Cochran, where he said there was a house on it.
Okay, let me pull that up.
And it may be here, I just can't, I'm not finding it.
So in the administrative law judge's order on page, I believe bottom of page 1 and page 2, he references several exhibits. Do you know which exhibit that was?
What I know I don't know from the date of the trial.
Okay, yeah. So the administrative judge identified the following exhibits that were entered into the record on this vacant parcel. That being Exhibit 1, the taxpayer's letter to the State Board of Equalization. Exhibit 2, the taxpayer's comparable property. Exhibit 3, the Lancer Road comparable properties. Exhibit 4, the taxpayer's comparable sales. Exhibit 5, the subject property parcel map. Exhibit 6, aerial map of the subject property. Exhibit 7, usable area map of the subject property. Exhibit 8, the change of assessment notice of the subject property. Exhibit 9, photos of the subject property. And Exhibit 10, the assessor's office's valuation analysis. Those are the only exhibits. I'm sorry, go ahead, Mr. Hafner.
No, go ahead.
Those are the only exhibits that we have as part of this record. I will frankly note that we do have your other property, the 132016 appeal. That is the improved parcel with the, I believe, the home on it. I will note that the administrative records do appear different for those two appeals. It's my understanding the administrative judge, for instance, on page 2 of that order, there are over 30 exhibits, whereas for this vacant parcel, there are only noted to have been 10 exhibits. I will frankly note that there's differences in the administrative record for those two properties. So right now, I just read through the order for the unimproved parcel. I understand that there's these properties are neighboring. Just in order to make sure we keep the administrative record clear, we're doing one specific parcel at a time. So we're just doing the unimproved parcel and the administrative record for that unimproved parcel. And so that unimproved parcel only has an administrative record with 10 exhibits before the administrative law judge.
How am I to address information that we submitted that's not in that And the judge references it. So he's reviewing that information, but it's not referenced as an exhibit. Because none of those exhibits that are listed
Are you able?
have,
Sorry.
have any information about me submitting any property with a home on it, which is what Judge Cochran states in his decision, that the comparables that I submitted have a home on them, and therefore he said, let me get the exact wording of it.
So, Mr. Hafner, you have two options. If you're able to correct the exhibits you believe are missing from this record and state why, you will need to do so in writing and send it to me almost immediately. Otherwise, we will have to continue the hearing on this one parcel today.
Yep, I can send it to you immediately. I mean, these were submitted, initially, all under, all the documents are initially submitted under one filing. I mean, you couldn't file them separately, so everything was submitted together initially way back in 2020.
You have to specifically identify what exhibits you
But I'll-
believe are missing, so I can make a ruling on whether there actually exists an issue with that.
Yep. I'm gonna send it to you right now. Just let me know. Yeah, board. I think you have to email on the board.
My email address again is robin.pope@cot.tn.gov. In the meantime, Mr. Lee, do you notice anything missing from the administrative record for this appeal?
No, Your Honor, both parties, we object to the submission of exhibits at this late date, additional exhibits. The record was provided to both parties. Judge Cochran has identified those exhibits in his order, the 10 exhibits, and that was the exhibits. The document that I believe Mr. Heffner is talking about was pre-filed with the original appeal. It was not made an exhibit at the hearing. So therefore, it is not a part of the exhibits for the hearing itself.
Mr. Pope, that's not a correct statement because Judge Cochran references that in his decision. So he's
I'm sorry.
referencing a document that was submitted at the time.
I just want to be really clear. So I unfortunately, you can't say that. I need to know very specifically what documents you are referring to. I know
Yep,
it's very sensitive. Yeah.
Yep, I'm sending it to you right now.
Mr. Lee, I will, of course, if you were not copied on that, I will. Or we can print it out and come back.
It is sent, so you should be getting it anytime.
I'm just refreshing my email.
Mr. Pope, it's page 4 of Judge Cochran's decision. It's just underneath where it says final decision, order number 2. He states further, the taxpayers' comparable properties are not vacant and containing houses, so the comparisons of the subject property are simply not reliable. And he doesn't reference any exhibits.
Correct. So what is so what are you saying is the issue, or what exhibits are you saying are
Well-
missing?
The one I just sent you is missing.
Okay, I'm still updating my email. I have not yet received your email.
Your Honor, the record does not reflect that document was made an exhibit. It may have been argued, it may have been, discussed. It was not made a formal exhibit for the record. The taxpayer has had ample time to correct the record if there was a error in the administrative record. The notice and the list of those was sent out, 11/3. Well, I think it was prior to that. The notice, though, is a part of the record where it was sent to both parties. I'm not understanding, the administrative judge found that the evidence was not ample and could not be relied on because he had a finding of fact that the taxpayers' comparable properties are not vacant and containing houses. So the conclusions, the comparisons with the subject property are not simple, reliable. That's his finding of fact. I don't know what Mr. Hefner's.
I still have not received any documents from Mr. Hafner, and I'm refreshing my email. Mr. Hafner, you might want to make sure you
Yep.
send it. My emails. ROBIN.POPE.
Yep.
COT.TN.GOV.
And of course, we ask that I be copied on that, any filings
Yep.
with it, even though I do not have
will.
access to my computer at this time.
I also am checking my junk email folder. I'm not seeing anything in there.
Yeah, I'm sending it again.
Give it a minute more. So what's going to happen here is when I receive that document, I will forward to Mr. Lee if you haven't copied him, and or we'll see if we can print out a copy to review it. I'll see if Mr. Lee has any further objection about correcting the administrative record, if that needs to happen. If it's not clear from the administrative law judge's decision that that document was part of the decision or an exhibit in that case, and or if we can locate that it currently is a exhibit marked in the administrative record,
Well-
otherwise just continue. If we're not able to authenticate it, go from there. Give it just a minute more. Okay. Plug in my computer. All right, I've updated my email again. I still have not received it. I'm not sure what the issue may be, Mr. Hafner. I will note, data
Yeah,
said,
okay.
notice of hearing was sent out over a month ago, as well as this hearing had been previously continued, and we've shared the administrative record multiple times. Excuse me.
Okay,
So with
yeah,
that
I've sent it three times, but I don't know if you check again, but I'll go ahead.
I'm just going to officially note for the record that is the procedure that has happened to today. So for our commission members and for Mr. Lee, we previously sent a copy of the administrative record to both parties using Microsoft OneDrive. And then we also detail, as you might have seen in the notice of hearing, specifically we label all the exhibit names that are included as part of the administrative record. That was provided to both of the parties multiple times, including in advance of this hearing. As of today, I did not receive anything. I asked the parties to confirm. Mr. Lee confirms that the administrative record is correct for this specific appeal number. Mr. Hafner, I did just receive that attachment. Mr. Lee, I will say it looks for like an appraisal for property located at 543 Dickey Valley Road, Harriman, Tennessee. I'll forward you this email.
So, Mr. Hefner, are you saying this was an exhibit that was entered by you, on behalf of you during the hearing that the judge did not mark it as an exhibit?
It most definitely was. This was one of the prime pieces of evidence that we had. It's in it, that whole valuation of what we thought the value is, why it had decreased, was based on its appraisal report.
Was this an appraisal report of the subject property?
It was of adjoining property, and this is what we discussed in the meeting, is.
And the appraiser was not present to testify, correct?
Can you repeat that, Mr. Lee?
The appraiser was not present to testify, correct?
He was not there, correct.
That might have been part of the issue, Mr. Pope, is the appraiser was not there. There was probably an objection in the record to submitting an appraisal where there's no witness to verify that. Therefore, it is hearsay and inadmissible.
But it was still referenced to. The judge used that as a reference to make a statement. There is no other evidence that I have submitted with any land values that have a home on it.
So what I'm seeing
So
in the record is we have two different parcels here. We have two different decisions. We have the appeal number 132015. As I noted previously, the administrative record for the two appeals are different. The administrative judge for the appeal we are currently on, that being appeal 132015, only noted, let's see where there's 10 exhibits in his initial decision in order. The document I've been presented with appears to be an exhibit in our other case for today that we will do next, but not as part of this administrative record. I'm not sure what point that is, Mr.
I'm sorry.
Mr. Lee. I will note that there is a footnote in our other decision that says the appraiser was not there to testify, but it was entered as an exhibit in that case. We do not have that same for this vacant parcel. Mr. Hafner, I understand your contention that the order was referred to. I believe you said on page 3 or 4 about the
Page 4. Page 4.
Mr. Pope, I'm confused because the judge's finding was that Mr. Hefner's, the taxpayer's appraisals or his analysis concerned land, the parcels were not vacant. This appraisal that I believe there is a house on this appraisal. So therefore, the statement, the finding of fact of the administrative judge is correct.
just one moment.
No, the statement says further taxes comparable properties are not vacant in containing houses.
That is correct. That this appraisal shows this property is not vacant, correct?
One moment, gentlemen.
Yeah, but that's why it's referring to this appraisal report. That's the point I'm making. There are no other documents I've submitted that have non-vacant properties on it. So the judge is referring to this document when he's looking at it. I haven't submitted any other land values for this appeal number 132015 that have homes on them. So this is the only document that Judge Cochran could be referring to. The other piece of information I submitted has about 8 just straight land properties.
I will note, I'm going to rule on this issue. I'm going to rule that this, the document you referred to me, Mr. Hafner, although I believe is included in our other appeal for today, was not made a part of the administrative record for the vacant parcel we were about to discuss. So therefore, I will not add it to the administrative record. Even if I were, I would say the late hour of this correction makes it kind of untenable to do that at this time. I will note that under the standard of review that we are hearing cases today, the review hearing is to be confined to the record, except only in cases where procedural irregularities are not shown in the record. I don't consider this missing exhibit to be a procedural irregularity justifying admission at this point in time. So therefore, we're not going to add it into this administrative record. But I will tell you, and I will note that it does appear to be part of a record in our next appeal, just for everyone's edification on that. But with regards to the vacant parcel and appeal number 132015, we're not going to include it in part of the record today. And the reason why I say that again, just for everyone's understanding, is that as we get into arguments, if you were going to refer to facts or evidence, I may ask you to specifically identify which part of the record you are referring to, and I will need you to do that using the list that was previously provided in the notice of hearing for this appeal number, that being 132015, the 10 exhibits as noted in the initial decision and order of Judge Jerome Cochran.
All right, thank you. I understand.
With that, Mr. Hafner, I believe you are our appellant today, and Mr. Lee is the appellee or the respondent here. So the procedure is we'll let you start. I'll have Mr. Lee go, and then I'll give you a brief opportunity to respond before we enter deliberations. As a reminder, our commission members can ask questions at any time, but I will specifically ask if you have questions before we move on to each next phase. With that said, we have the administrative record confirmed. Mr. Hafner, as soon as you are ready, please feel free to proceed with your initial argument.
The initial argument based on the information we have now is that neither party showed reliable information to justify any evaluation. So there's no justification. While it is possible that there can be large increases in a property year, that doesn't mean there's any justification in this case that there was. The second piece of information is that Judge Cochran, in his decision, said based on topography, he marked a 20% reduction. If you note the document, let me pull it up here. That's exhibit number 7. And this describes the usable acreage of that land. And what this is showing is of the 8.38 acres, that only 3.66 of those acres are usable due to a road, an easement, and a pond. So we feel that the 20% reduction does not meet the topography marked in this document, that it should be reduced, slightly over by 50%. In determining the, best use of a value, it's, what would a reasonable person buy in a market value, and they're using, over 8 acres as the comparison when over half of this property is a pond and road easement to access the second property that would be discussed.
Anything further, Mr. Hafner? Great, hearing none, do we have any questions from our commission members? at
No,
this time?
I do not
Oh,
have any
sorry.
more at this time.
Any questions from our commission members? Seeing none. All right, I'll hand it over to Mr. Lee.
Thank you, Mr. Pope. The assessor of property request, while we do not agree with the administrative judge's decision, we do not think there's a basis for him to pluck out of the air a 20% topo adjustment with no market analysis. We did not appeal that. We're asking the board, the commission, to affirm the administrative judge's decision. It is clear the procedure before this board is you should not substitute your weight of evidence for the administrative judge's weight of evidence at the administrative hearing. The assessor did provide a analysis showing a slight reduction in the property based on a foot valuation of the property. This property is accessed through a cove, and it sits in front of the second property. And so it is the value that the judge come out with, $481,120. I think while there's concerns that is supported by the evidence, we're not asking the commission to reweigh the evidence because that is not within your authority in our position. The taxpayer is asking that you do reweigh the evidence and make a adjustment to this based on one exhibit. The judge has already heard this case. He's already made that determination. We ask that you affirm the administrative law judge's decision.
Any questions from our commission at this time? Hearing and seeing none. Mr. Hafner, if you have any final comments?
Just to repeat the last comments that Mr. Lee had, the judge disregarded those in his statement as well. So really there's the front footage, the things that Mr. Lee just referenced to, the judge has said that was not reliable either. Our main argument is the massive increase from a valuation of $153,000 to $481,000, and the fact that we did submit ample evidence to the judge regarding topography, but there's no basis for his only 20% reduction when the topography calls for over a 50% reduction.
Okay, any final questions from our commission members? Seeing none, we'll enter deliberations. Again, at this time, there'll be no more communication between the parties and our commission members. Commission members, you may ask questions of Mr. Matthew Childress, your counsel. I don't know if I read it previously, but once again, the general charge is the same. Did the administrative law judge misapply the law cited in this case? Did the judge act outside of his scope of authority? Or was the decision otherwise supported by substantial and material evidence? Hand it over to Mr. Russ.
Okay. This would be a case of our substituting our opinion for the administrative law judge's opinion. And we cannot do that. I didn't find there wasn't much of anything in here. So I think we would just have to affirm what the administrative law judge said, what the decision. Let's go down.
I totally agree. It's a situation where the administrative law judge did look over data and made some assumptions with regard to the topography of the site and attempted to make some adjustment on it. Up to the opinion of the administrative law judge. So therefore, I don't in a position to make any changes.
I totally agree. If the county had asked for it to go back, reconsider the value, I would probably do that. Because I think the pond and the 2% reduction reviewing it myself, which we don't do. But we do get all the evidence and we do look at it. And it's an entrance. It's like saying the gate at Biltmore is a detriment to takes up space. Property. I mean, it is an estate. It is nice. That this is his entrance to his home, and that's the best, nice and best use is what he was saying. It's pond takes up some space on that. So it sounds like the pond is driving by a beautiful large lake, plus instead of a minus. And there is a slope down to the water. Okay, and that is topo. There's also a lake on the upper. So I think that, I mean, I'm totally for judge's decision that
Mr. Rogers.
Thank you. The main issue here, I think, as was alluded to in the judge's order, was the general lack of evidence on both sides. So while I'm very skeptical of the the initial value and the reduction that was applied by the judge, I can't substitute my opinion for what was already decided in this case. There's no justification for that, so I agree that affirming the judge's decision is the only way to reasonably go in this case.
Okay, can you want to make that a motion?
Sure. Yeah, I'd like to make a motion to uphold the judge's decision.
Okay, do we have a second?
A second.
Okay. All those in favor, please say aye.
Aye.
Any opposed?
No, for the
Thank
record,
you.
the ayes have it. So that concludes our business on this one appeal. We still have one more to go. We will issue a formal written decision and within the next 90 days and send a copy to the parties. Moving on, our next appeal will be for our other parcel, that being appeal number 132016. Page 2, it's noted as the property located at 539 Dickey Valley Road in Harriman, Tennessee. Parcel 28.013.01. That's what I have at the top of that order. I'm gonna hand out a copy of the initial decision order again to our commission members, and then go through it pretty quickly. The case caption reads, in regard to Jonathan and Jenny Hafner, Roane County Property ID, as I said, 28011301, tax year 2020 and 2021, appeal number 132016. Initial decision order statement of the case. The Roane County Board of Equalization, hereinafter the local board, has valued the subject property for tax purposes as follows: a land value of $549,900, an improvement value of $1,523,500, a total value of $2,703,400, and an assessment of $518,350. The taxpayer filed an appeal with the State Board of Equalization, hereinafter State Board, on August 16, 2020. The taxpayers are further requesting to amend appeal to include tax year 2021. The undersigned administrative judge conducted a hearing on this matter on December 7, 2021 in Kingston, Roane County, Tennessee. The appellants Jonathan and Jenny Hafner represented themselves at the hearing. Hereinafter the taxpayers, the Roane County Assessor of Property was represented by its attorney, Robert Lee, hereinafter the Assessor's Office. Statement of the evidence. The taxpayers testified on their own behalf, and the Assessor's Office's witnesses included Molly Hardup, the Assessor of Property for Roane County, and Richard New, an independent appraiser. The following exhibits were introduced. Exhibit 1, the taxpayer's letter to the State Board of Equalization. Exhibit 2, the 2016 initial order concerning the value of the subject property. Exhibit 3, the purchase and sale agreement for the subject property. Exhibit 4, the change assessment certification for the subject property. Exhibit 5, green energy property tax assessment documents. Exhibit 6, aerial map of the subject property. Exhibit 7, documents regarding the history of the subject property. Exhibit 8, appraisal of the adjacent property. Exhibit 9, the taxpayer's comparable sales. Exhibit 10, appraisal of the subject property. And he notes at footnote 1, the appraiser was not present to testify. Exhibit 11, septic system information. Exhibit 12, Drive It versus Stucco article. Exhibit 13, landscaping and walkway bills. Exhibit 14, elevation certificate. Exhibit 15, floodplain map. Exhibit 16A, the taxpayer's photo of the subject property. Exhibit 16B, the assessor's office's photos of the subject property. Exhibit 17, the taxpayer's comparable sale on Battery Street. Exhibit 18, the taxpayer's comparable sale on Grand Oaks Drive. Exhibit 19, the taxpayer's comparable sale on Buttermilk Road. Exhibit 20, the taxpayer's comparable sales on Shorewood Shores. Exhibit 21, taxpayer's comparable, excuse me, I think I read that. Exhibit 22, the taxpayer's comparable sale on Kings Drive. Exhibit 23, the taxpayer's comparable sale on Little Emery Road. Exhibit 24, newspaper article on Harriman. Exhibit 25, the State Board of Equalization 2020 Tax Aggregate Report of Tennessee. Exhibit 26, floor plan for the house on the subject property. Exhibit 27, the taxpayer's comparable sale on Bayshore Drive. Exhibit 28, aerial photo of the subject property. Exhibit 29, homeowner's policy packet. Exhibit 30, the assessor's office's appraisal report. And Exhibit 31, the 2020 tax card for the subject property. Findings of facts and conclusions of law. The subject property in this appeal consists of a house on approximately 5.38 acres at 539 Dickey Valley Road in Harriman, Tennessee. Taxpayers contended that the subject property should be valued at $964,200. The assessor's office requested the local board's decision of $2,073,400 for the subject property valuation be modified to $1,575,000 based on a valuation analysis performed by an independent appraiser. The basis of valuation set out in Tennessee Code annotated at section 67-5-601 subsection A is that the value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing buyer without consideration of speculative values. As the party seeking to change the current assessment of the subject property, the appellant has the burden of proof in this administrative proceeding. State Board Rule 0600-1-.11 subsection 1. At the hearing, the taxpayer, Jonathan Hafner, testified that the subject property consists of a house with a two-car garage on 5.3 acres of land that was purchased for $1.65 million in 2014, which included an adjoining tract of land. According to the witness, surrounding land values in Roane County have decreased since 2015, except his, which increased by 26% since the last assessment. He further testified that since the last assessment, the only improvement to the subject property was the addition of structures containing solar panels. The taxpayer, Dr. Hafner, also testified about issues with the house, including that it is built with stucco, which lowers the house's value. Other issues with the house, according to Dr. Hafner, are potential mold issues, deterioration issues, gravel road, no phone or cable lines, no boat dock or ramp, and not located in subdivision. The taxpayer introduced comparable sales of county properties that he claimed demonstrated decreased land values in the county. Under cross-examination, Dr. Hafner testified that the subject property has 2,000 feet of lake frontage and that the structures containing the solar panels can also be used for storage. He also testified that the subject property's value has decreased based on adjacent property assessments. However, no market analysis was performed by the taxpayers. Dr. Hafner further stated during cross-examination that the home contained 6,072 square feet and was insured for $1,997,000. Taxpayer Jenny Hafner testified that their insurance policy overstated the value of their house and that she took issue with the appraisal offered by the assessor's office. She also testified that the value should be reduced based on the lack of a concrete driveway. The assessor's office's witness, Richard New, a certified appraiser, prepared an appraisal report based on his evaluation of the subject property. Mr. New testified that based on his evaluation of the subject property, using the cost and sales approach, that the value of the subject property was $1,575,000. Mr. New further testified that his valuation was based on assumptions regarding the interior of the house due to him not being allowed by the taxpayers to inspect the interior. Based on a review of the testimony and evidence, the appraisal report provided by the assessor's office is compelling and appears to be a more accurate reflection of the value of the subject property. Taxpayers testified that the assessed value of their property had increased at a higher percentage than in other nearby properties. However, the Assessment Appeals Commission has repeatedly rejected arguments based on the amount by which an appraisal has increased as a consequence of reappraisal. For example, the commission rejected such an argument in E.B. Kissel Jr., reasoning in pertinent part as follows. The rate of increase in the assessment of the subject property since the last reappraisal or even last year may be alarming, but is not evidence the value is wrong. It is conceivable that values may change dramatically for some properties, even over so short of time as a year. Further, the taxpayer's use of sales prices of nearby properties is not a reliable indicator of property values, as the values they rely on fail to make adjustments in values when compared to the subject property. Factors such as age, square footage, building materials, etc., were not taken into account in the comparable sales listed in their comparable sales. So these comparable sales are not a reliable indicator of what the home values are compared to the subject property. The Assessment Appeals Commission has said that for comparable sales to be relevant, they must be properly adjusted. In E.B. Kissel Jr., the commission said the best evidence of the present value of a residential property is generally sales of properties comparable to the subject, comparable in features relevant to value. Perfect comparability is not required. But relevant differences should be explained and accounted for by reasonable adjustments. If evidence of a sale is presented without the required analysis of comparability, it is difficult or impossible for us to use the sale as an indicator of value. With respect to the structural issues, lack of concrete driveway and no cable or phone lines with the subject property, the taxpayer testified about, and his belief that these issues reduce the subject property's value. Unfortunately, merely reciting factors that could cause a diminution diminution in value does not establish the current appraisal exceeds market value. The Assessment Appeals Commission has ruled on numerous occasions that one must quantify the loss in value one contends has not been adequately considered. I got a note on, sorry, I paused because I got a note on our Teams call to speak into the microphone, but I believe that was delayed. If someone cannot hear me, please speak up. The Assessment Appeals, continuing on bottom of page 5, the Assessment Appeals Commission has ruled on numerous occasions that one must quantify the loss in value one contends has not been adequately considered. See, that is Fred and Ann Ruth Honeycutt, wherein the Assessment Appeals Commission ruled the taxpayers introduced insufficient evidence to quantify the loss in value from the stigma associated with a gasoline spill. The commission said in pertinent part, the assessor conceded that the gasoline spill affected the value of the property, but he asserted that his valuation already reflects a deduction of 15% for the effects of the spill. The administrative judge rejected Mr. Honeycutt's claim for an additional reduction in taxable value, noting that he had not produced evidence by which to quantify the effect of the stigma. The commission finds itself in the same position, conceding that the marketability of a property may be affected by a contamination of a neighboring property. We must have proof that allows us to quantify the loss in value, such as sales of comparable properties. Absent this proof here, we must accept as sufficient the assessor's attempts to reflect environmental conditions in the present value of the property. Similarly, in Kenneth R. and Rebecca L. Adams, the commission ruled in relevant part. The taxpayer also claimed the land value set by the assessing authorities was too high. In support of that position, she claimed that the use of surrounding property detracted from the value of their property. As to the assertion the use of properties has a detrimental effect on the value of the subject property, that assertion, without some valid method of quantifying the same, is meaningless. Finally, with respect to the taxpayer's appraisal, little consideration could be given to it due to the fact that the appraiser was not made available to the assessor's office at the hearing in order for him to be cross-examined regarding his appraisal. The assessor countered with properly adjusted comparable sales contained in their appraisal report. These sales established a range in value for the subject property of $164 per square foot to $398 per square foot. This led the assessor's office to recommend a value of $235 per square foot, which comes to $1,570,000 for the subject property. Further, the assessor's office's appraisal also provided a value under a cost approach, which led to a value of $1,580,000. Both approaches seem reliable and support the contended value of the assessor's office. Respectfully, the evidence introduced by the taxpayer is inadequate and cannot be relied on in this matter. The assessor's office comparable sales approach and cost approach analysis supports the modification of the final decision of the local board. On page 7, it is therefore ordered that the following values be adopted for tax years 2020 and 2021. A land value of $325,000, an improvement value of $1,250,000, for a total value of $1,575,000, and an assessment of $393,750. It continues on page 7, listing the available remedies, including appeal to this body. And then on page 8, the order concludes, noting that it was issued by Judge Jerome Cochran on February 1st, 2022, with a certificate of service noting it was sent to the parties on that same date. Again, with this appeal, like we did in our last appeal, the appeal was originally scheduled and then continued to today's date. A notice of hearing was sent out on November 3rd, 2022 for this appeal, that being again appeal number 132016. On page 2 of that notice of hearing, we identified those exhibits that were part of the administrative record. As a preliminary matter, I will note that the document Mr. Hafner sent me on our last one is included in this list of exhibits. I believe is exhibit number 8, appraisal of adjacent property. It does match the both date, page number being 30 pages, and located at 543 Dickey Valley Road. So that exhibit is included within this appeal. I will again ask the parties, are there any issues we need to discuss about? Sorry, is there a
Can we
question?
do a quick break?
Yeah, let's do a break. We'll come back at 11:40.
I heard the chirping. I heard chirping. Yeah, so I assumed that was one of them. There's a chirp when the battery gets low. Oh, is that what that was? Oh, it was like a fire alarm.
So that changes.
Okay, I think are we about ready to get back on the record? Okay, yeah, just one more minute. Just giving one of our commission members an extra moment, and then once he gets back, we can go ahead and get back on the record and,
Got to talking way too much.
we now have our commission fully back. Mr. Lee, Mr. Hafner, are you still on the line?
Yes.
We left off, I went through the administrative record for this appeal and noted that the exhibit you had emailed me previously is included in this, this record for this appeal, this being the parcel with the improved home on it. I believe it's a home residential property. With that said, unless there's any issues with the administrative record to correct, we'll otherwise enter into arguments. Mr. Hafner, as the appellants in these proceedings, you will again go first. And so I'm looking at my commission members. Commission members, just let us know when you're ready to begin. Okay, I got the nod from our commission members. So Mr. Hafner, feel free to proceed with your arguments about, sorry, something I usually ask the parties too is if you could define it specifically, what are you asking from the commission in this appeal, and why do you believe the administrative law judge's decision was incorrectly decided?
We're asking for a reduction in the value primarily based upon unlawful analysis and methodology of Roane County's appraiser, independent appraiser they used. Primarily looking, there's one primary comparable that we're looking to use as the main comparable property. And that is our main contention.
And you may continue with the rest of your argument as well.
Point number one is that we are appealing for years 2020, 2021, and 2022. I think the first 2 years were referenced earlier, and that was on our taxpayer appeal, which I believe is exhibit dated 2022, March 1st, exhibit A. And so we are appealing all 3 years. The second point.
Hold on a second, Mr. Hafner. So as I read this case caption, I do see your appeal filing noting tax year 2022. In order to include subsequent years, a couple of things have to happen. So, sorry, as a preliminary issue, I don't mean to totally disrail your argument and things like that. I just have to check couple of things. All right, so we have certain rules about when you're able to amend to include a subsequent tax year, particularly if the county has undergone a reappraisal in tax year 22, and I'm checking to see if Roane County's reappraised. And
we're on a 5-year cycle.
okay, no, their next reappraisal is 2025. So again, we're looking at 2020 and 2021. I understand you'd like to amend this appeal to include tax year 2022. You may do so. Mr. Lee, do you have any objection to including tax year 2022?
Yes, Your Honor. It's our understanding 2022 was not an appeal. Was the appeal?
You can amend at the commission level.
Mr. Pope, on March, we sent this appeal in March 1st, 2022, after Judge
Yeah.
Cochran's decision. Judge Cochran's, the initial trial was in 2021. So we couldn't have had appealed the decision for 2022 and 2021 if we didn't know the decision wasn't even going to be back until 2022.
Yeah, but so Mr. Hafner, how it works at the commission level, now that we're here. So every tax year is appealable. You can appeal every tax year on its own. You can go back to the county board every year. If you have an appeal at the State Board of Equalization, you can amend your appeal to include subsequent years, so long as there's not been a material change in the property. And so generally speaking, if someone wants to amend their appeal, they can note that they want to amend their appeal. I do see on your March 1st, 2022 filing to the commission that you did note tax year 2022 on that. I'm looking to Mr. Lee to see if he has any objection, including that tax year 2022. So Mr. Lee, do you have an objection to including tax year 22 with this appeal?
Yes, we do. Appeal was not filed appropriately with the State Board of Equalization. I think the process to amend requires a notice to be filed with the State Board of Equalization that is being sought to amend. It was my understanding that the taxpayer and the assessor have reached a conclusion for 2022. And so therefore, we are not prepared to go forward with 2022 for this year. The mere adopting a heading is not sufficient, in our opinion. Therefore, that is not properly, the value had not even been certified by the County Board of Equalization in March of 2022. So there was no value to appeal to 2022 to the State Board of Equalization. The value would not have been certified until June at the conclusion of the county board. There's preliminary values, and taxpayers can appeal to the County Board of Equalization. Each year stands on its own. There was no appeal to the County Board of Equalization. There's nothing to file. I believe the procedure with the State Board is you have to file by a certain date to amend an existing appeal that was put in place by Ms. Knox. There was a letter.
It's not a State Board rule. It's generally speaking a best practice indicator.
We would object to adding 2022 at this time.
Okay.
We're only appealing any potential changes that come as a result of this decision, which we would not have known.
Okay, so maybe we're explaining some of the procedural elements, I will say, and we can kind of go from there. So, Mr. Hafner, I will maybe note judicially that if you were to amend to include tax year 2022, then your assessment for tax year 2022 would be the same, whatever happens at the end of today's hearing. So if the commission affirms the decision, your 2022 market value would become $1,575,000 for tax purposes, as well as the assessment then being $393,750. I will, if Mr. Lee doesn't mind me taking the liberty, pull up the current 22 assessment to show what it is on this specific parcel. Excuse me one moment.
It's the same.
Oh, sorry, we're looking at 2022. Yeah, okay. So I'll note the real estate assessment data currently has it at total market appraisal of $2,136,000 as the total market for an assessment of $534,000. Mr. Lee, I understand your objection is based on the fact that the late notice of this, the taxpayer is noticing at the hearing verbally that they would like to include 2022. I will note there's no limitation on when the taxpayer may amend an appeal to include 2022. However, since this body does not have findings of fact, They will not be finding a different value for tax year 2022. It's simply a carrying forward of the administrative law judge's decision. In the case, in the event the commission decides to remand this case for further proceedings, the judge may then, that would also apply to 2022 as the case had been amended to include it. You can amend an appeal with the State Board of Equalization. The precipice being that you're waiting on your decision to know if you need to go back to the county board.
Yeah,
Mr. Lee.
Mr. Pope, it's my understanding 2022 has different improvements on the property. So there's a substantial change from the prior years. So therefore, it was also my understanding that the taxpayer, the assessor, had determined the value for 2022, including the new improvements. So therefore, that's why the value is different on the certified value.
So the material change.
Mr. Pope,
It's a material
Okay.
change in the property.
Yeah, Mr. Hapner, I'll give you now.
Yep.
Now I'll hand it back to you to officially respond. What is your
Yep.
comment?
There have been no material improvements in the property. We had received a permit to build a pool. The pool had not even been started at the beginning of 2022. And the county increased our assessment by over $300,000 when there was no physical structure that had even been started. I have spoken with the Maui Hardup. They have come out and evaluated the property. They have readjusted that 22 assessment. I have a physical copy of a 2022 assessment that still has it at the 1.57 million. So that is inaccurate for Mr. Lee.
Okay.
And it's actually, it was a falsification by the county because they tried increasing our improvement value based on a permit
Okay,
with
so,
no physical structure on it.
yes. So, Mr. Hafner, the rules of state board. So if you have any sort of material change, which typically would include a permit, so I guess I will ask you is
I can look it up. I can send you the
the
copy of
property
the
change-
form that Molly Hardup sent me.
So she sent you an assessment change notice for tax year 2022. Is that okay?
She sure did.
Hold on a moment.
Now, I'm
It's
just
not-
checking to see if I've scanned it in. I'm just checking to see if I've scanned it in yet. I know I have it. I'm just trying to see if I can scan it in and I can send it to you. I'm pretty sure I've already scanned it in.
So the issue that we have is the board cannot carry forward the adjudication of material change in the property, nor is this commission set up to make a finding of fact as to whether there's been a material change in the property. Because of those two factors, I'm going to deny your request to include tax year 2020. Again, as we are here currently at the hearing and all our documentation did not have tax year 2022 on it, is my understanding. With that, so it will only apply for tax year 2021, 2020, and 2020 and 2021. I will say this does not maybe prevent you from filing a tax year 2022 appeal. I do not understand the basis or what assessment change notice or even know the date of that. All those can be factors and implicating like when you have time frame for appeal. Just for purposes of this appeal before the commission, this decision will only go through tax years 2020, 2021. If it is remanded, you can renew your request to amend to include tax year 2022, but the commission is not set up to make a finding of fact as to whether there has or has not been a material change. And since Mr. Lee has argued that there's a factual issue there, I cannot make that finding here for you today. So we're, and given the late notice of this appeal, we are all here. We're ready to do this appeal today, and I didn't have any more advance notice of that. This decision will only apply for tax years 2020 and 2021.
Okay. Can it be duly noted that this change was done at the State Board of Equalization meeting and that Mr. Robert Lee had no problems with amending that appeal for the 2021 year at that meeting?
Yes, that's noted in the decision of the administrative law judge. Other than that, Mr. Hafner, I apologize for interrupting your initial argument. You may continue your argument about this decision.
Yeah. Point number 2 comes from the initial decision and order by Judge Cochran, page 1. He lists the total value as $2.7 million 3,400, which is, it's an unlawful, inaccurate, misleading number. I don't know where he gets it from. It doesn't even add up to the values on the front of the page. If you add the land value and improvement value, it is 2,070,400. And that is also repeated in Mr. Robert Lee's briefing, which I believe is the briefing is dated that Mr. Lee submitted. Let me pull it back up here. The date is 2022, November 16th. Mr. Lee states the administrative judge initial decision reduced the value from 2.7,003,400 to 1.575 million based on Mr. New's appraisal submitted. That is also a misleading and inaccurate statement. The statement by Judge Cochran is, I feel just unlawful because he misrepresented the number. I don't know where he gets it from.
Anything else, Mr. Hafner?
Number 2, on page 3 of Judge Cochran's administrative decision, he then lists states the subject on the second line. He says the assessor's office requested the local board's decision of 2,073,400 for the subject's property. Valuation should be modified. So it doesn't seem like he's consistent with the information he's providing. Point number 3, on the 4th paragraph of that same page of Judge Cochran's decisions, it states, at the hearing, the taxpayer, Jonathan Hafner, testified that the subject property consists of a house with a 2-car garage on 5.3 acres of land that was purchased for $1.65 million in 2014. That information is also unlawful and inaccurate and misleading. If you reference the original purchase and sales agreement, which is Exhibit 7, it states that we purchased, well, I want to make sure I get exhibit right. It's a sales and purchase agreement. I'm sorry, it's Exhibit 3, I believe, is a purchase and sales agreement. And it states we purchased the combined properties, the one we already talked about on Appeal 132015, property 028.013.02, and the current subject being talked about. We purchased both parcels for $1.165 million. So Judge Cochran is stating here and setting the comparative price and misleading us to think that I paid $1.65 million for this property when the combined properties we've discussed, we paid $1.165 million for. According to Judge Aaron's decision back in 2015 appeal, he set the price of the 2 properties, and he separated that $1.165 million in his decision. He separated the one we already talked about as $153,000, and then he set the purchase price for this property that we are talking about right now at $1 million. And I have to go to that decision, but I believe it's $1,015,000. So Judge Cochran here is misleading us with this number and thinking that we purchased it for over $650,000 more than we actually did. And I basically never said that statement. I mean, I know what I purchased the property for.
Anything else, Mr. Hafner?
You need the reference number for Judge Aaron's, decision, the exhibit number, because that's what I'm just looking for.
Sure, I can help facilitate that.
But in that decision, he lists this current property. He divided, because he agreed with the decision of our purchase price, that the total combined properties was 1.165 million. And then he divided that up into, the previous property that he assessed for 153,000 and the current one for $1 million.
I'm displaying a copy of that initial decision and order he's referencing.
And that was over $1 million under.
Exhibit 2.
It logged me out. Yeah.
Is there anything else, Mr. Hafner?
No, I just want to make sure you're able to pull that up.
Yep, I have the decision pulled up.
So, so the initial point here is that Mr. Lee and Judge Cochran are kind of misrepresenting, which is unlawful, where our starting point is. Starting from 2015, this property, according to Judge Aaron, was valued at just over $1 million. And that's what we paid. And what we paid for it was not 1.65 million. The next point I want to address is really Judge Cochran's really lack of addressing the law regarding the green energy property we have on our facility. So currently we have we built structures to put solar panels on. In Mr. New's appraisal, there's really no reference or no reduction according to the state law. And the exhibit, let me just find it here. Is Exhibit 5. If you'll pull up Exhibit 5.
Right, I am now going to share Exhibit 5, which is the Green Energy Property Tax Assessment article. It appeared.
Yep, and it dated March 12, 2021. If you'll scroll to the second page where it says summary.
Yep, scrolled.
And this is where the legal information, and according to in Senate Bill 1000 is supplied afterwards. But according to state law, solar energy, the state bill says it's, the max that you can assess a green energy facility is 1/3 of a total installed cost. That's Senate Bill 100. For solar energy, it states here, the max you can be assessed is 12.5% of the installed cost for solar and other green energy sources. The second paragraph, it notes you need a TDEC certification. which if you keep scrolling past Senate Bill, these are all the supporting Tennessee codes and laws. But if you keep scrolling down, there is a TDEC certification for a green energy facility. These structures, which Judge Cochran states can also be used for storage. Yes, they can be used for storage because they were built to store green energy batteries. Those facilities have the inverters for the green energy. And so those structures were specifically built for green energy production. If you pass it's page 9 of all those documents, and it's the company that installed those panels, Green Earth Solar, and it's a letter dated June 16th, 2016, addressed to myself. And and let me know when you're there.
We're there.
In the first paragraph, and this just states that the solar installers know that this reduces the property taxes on this amount. In the last paragraph, or it's the second one, this certification exempts your project from any state sales or use taxes and therefore eliminates the requirement that we collect taxes on any equipment or materials used on this project. Additionally, the certification reduces the property taxes to a nominal amount, referencing the first page. And I've supplied additional information. The next page is the TDEC, the applications, all the documentation supporting this facility as a green energy production facility. The last 2 pages of this document show the structures. And you can see by their asymmetrical design in their structure that these buildings were built.
A 37-page document for this exhibit. Do you know which page you're on?
Yeah, very last page, page 37.
Yes, I have a picture, 2 pictures of that.
Yep. And so, I am contending that Judge Cochran was unlawful in ignoring the state law for green energy production facilities. So what we're requesting is whatever the final value of these structures are determined to be, that it should only be assessed at maximum 12.5% of the assessed values of these structures. There's no basis, just because you can store things in there, that disregards them as green energy facilities. Part of the facilities require that you have space to put batteries to store the green energy facility. And that concludes that portion of our argument.
Wait,
And
sorry.
if you
Go ahead,
would just
Mr. Howe.
leave that document open, because I'll reference it in just a second. And it's just page right before it, page 36.
Yes, I see a page saying Addendum 1, insurance requirements for
Yep.
participants. All right, continue when you're ready.
Yep. And referencing back to the initial decision and order. And this is regarding Mr. Robert Lee's use of the homeowner's insurance as evidence for value of the property, which is on page 4 at the very top. We had argued against using this document previously because Mr. Lee is not an expert in insurance. This document,
Your
just
Honor,
like,
that-
So we have an objection from Mr. Lee for the statement that he's not an expert in insurance.
Insurance-
Being
insu-
sustained. Mr. Hafner, I'm gonna maybe try to help facilitate your argument and maybe ask that you provide a little more rational link between what the error in the initial decision order that you're
Yep.
claiming is.
the error was that Mr. Lee submitted incomplete information. Just like in the previous case, this document was not supplied in the information to the state at the State Board of Equalization. This was not presented. This was only presented at the State Board of Equalization. It was not presented ahead of time to allow us to prepare for any defense of this document. In addition, this document was incompletely submitted. When we submitted this information to Mr. Lee in exchange of documents at the very beginning, we actually submitted 2 homeowners insurance policies, as well as a letter stating that the initial homeowners insurance on this policy was at just over $1 million in conjunction with a purchase price. When we moved we purchased
You're
this house
referring to
in 2000.
You're referring to
Yep.
another exhibit at this point?
I'm referring to the fact that this exhibit was admitted with, and it's partially misleading and falsifying information that Judge Cochran allowed without allowing the full document to be submitted. And that's what I am contending on this. This was a partial document. It's like pulling one page out of a document that was submitted and submitting it. It's misleading. And Judge Cochran allowed it because we also submitted a homeowner's insurance policy before we moved here when there were no assets in the home, showing that the home was only insured for $1 million. But Judge Cochran, I believe, unlawfully allowed partial information that was submitted on the day, was not submitted to the state ahead of time, which was required, just like today. We're not allowed to have information submitted. This document was permitted at the State Board of Equalization and was not submitted prior to the State Board of Equalization. And there's unlawfully submitting partial information, which is misleading. Because an insurance policy also insures the assets in the home. It is not only to insure the value of the home itself. And our assets are over $1 million. So when you insure a home for $2 million, it is automatically insured the assets in the home for over $1 million. So it is more affordable for us to have overinsurance on the house than to pay additional money to cover our assets in the home. And that was the purpose of submitting all the documentation to Mr. Lee in exchange of information. And we submitted 2 homeowners insurance policies demonstrating that, as well as a letter. And he submitted on the day of the State Board of Equalization meeting partial information, which is misleading, which was unlawful for Judge Cochran to allow that to be submitted. That is our contention.
I think we understand that point. Do you have any other arguments about why the initial decision order was decided incorrectly?
Yes.
Proceed.
Next, I want to direct the attention to Mr. New's appraisal, which is Exhibit 30. And it's page 61. And this is the appraisal methodology and analysis report. And let me know if I'm speaking too loud. Like the previous counsel, I'm an ear, nose, and throat physician. I'm used to speaking loud to my deaf patients, and so sometimes I have to tone it down too. So if I'm speaking too loud, please let me know.
I think you're fine.
Okay.
I may need to interrupt. My hotel has a late checkout at 1 o'clock.
Okay.
And so I need to know whether to get the room for another day or.
We'll definitely conclude today. If you do need to leave, we will still have a quorum So it will be okay if you need to excuse yourself. I'm not sure how long it'll take you to get back. If you feel like you need to leave, that is okay.
Okay.
Assuming none of our commission members drop out on us, so we can continue to conclude business.
I think I can stay another 20 minutes maybe
Oh,
and
oh, yeah.
be okay.
I will try to make it as fast as I can. Am I ready to begin again?
Go ahead, please proceed.
So our main contention here is that this appraisal methodology analysis is unlawful on 2 points. And one, Mr. New basically did not use comparable properties. He went outside the county when there were multiple comparables in Roane County. It is unlawful to go outside the county to obtain your comparables when there are comparables within your county. The second aspect is on the lower portion, he did not make value adjustments for the property adjustments. According to USPAP, and that is all on page 61, according to standards of the Uniform Residential Appraisal Reporting, USPAP, what we're here for is that really what is a reasonable comparative alternative to this subject property. It is usually more favorable to use the grid system with a Fannie Mae reporting. But the important thing is to have dollar adjustments to make these properties equal. And that was not done, and that is unlawful. I want to point out some errors in this chart, which has a large significance. First, on
Okay, so
comparable.
at that point, I might kind of cut you off on there for terms
Yep.
of errors. We are here to review the decision of the administrative law judge. So if you want to talk about the part where the administrative judge relied on this appraisal report, we aren't going to go through the evidence. You can't just go through the evidence and say what you contend was wrong with the evidence, as much as you can point out what parts of Judge Cochran's decision you think unjustifiably or arbitrarily relied on this exhibit. So if you want to reference the initial decision in order.
Yep.
Yeah,
Based upon the initial decision and order, and it's on page 5, Judge Cochran even states the best evidence of the present value of a residential property is generally the sales of properties comparable to the subject. Comparable in features relevant to the value. Perfect comparability is not required, but relevant differences should be explained and accounted for by reasonable adjustments. If the evidence of a sale is presented without required analysis of comparability, it is difficult or impossible for us to use a sale as an indicator of value. And we are using that same law to contend that that was not done. Specifically,
Jerome's and Judge Cochran's order, when he talks about the appraisal, did he make a finding of fact that you say is arbitrary with regards to adopting or not adopting that appraisal?
Well, what we're saying is that he is saying he is contending the assessor countered with properly adjusted comparable sales contained in their appraisal report. And we are stating these are not comparable reports. Comparable 2, 3, and 4 are not even in the same county. So they are not comparable. And so we are saying that is unlawful for him to use comparables out of the county. With Judge Cochran is saying.
Your argument, if you want to, I think we understand the argument. I think the commission members have reviewed those documents. If you want to move on to your next point, your next argument.
So you understand that we're contending it is unlawful for the comparables, as well as there is no dollar adjustments for any of the property adjustments at the bottom.
Sure. And any questions from the commission on that point?
No.
This is not a question, but I will make a comment.
Again, just as close as you can to the microphone.
Okay. This is not a question, but I will make a comment. It is up to the appraiser where they choose which comparables to use, and there is no law anywhere saying where those comparable sales have to come from. So the market itself is the judge of where whether those comparables are appropriate or not. It's not it is not unlawful that he might have gone out of county to find a property that is most similar to the subject property.
That's correct. Okay. Any other arguments, Mr. Hafner?
We also were not provided a work file for this appraisal as well. So we don't have any quantitative data as support of this appraisal.
Is it okay if we go ahead and let Mr. Lee go? Mr. Prophet, I do understand if you need to leave, just raise your hand and we'll excuse you.
Okay.
Mr. Lee, I asked to go ahead. Or any more questions from the commission? Seeing none, Mr. Hafner, I'll give you an opportunity to respond to at the end.
Thank you. The assessor, the Roane County assessor property asked that the administrative judge's decision be upheld. There's no factual basis or any, it's a weighing of the evidence. And we've talked about that before in other commission decisions. The commission is not here to reweigh the evidence. The administrative judge gave weight to all the proper evidence of this. Mr. New, the county, when this was appealed, this is a high-end residential property in Roane County, very rare, probably in the top 5 to 7% of residential properties in Roane County. The Roane County assessor property obtained the services of an MAI appraiser. It's not noted that Mr. New is an MAI, Judge Cochran's decision, but he is. He's a licensed appraiser first off, but he's also an MAI certified appraiser. He did a independent fee simple analysis of this subject property, used the cost approach and the sales comparison approach. He did not use an income approach because that's not appropriate for this type of property. So he did sales. He did go outside the county because that is where the market is. He made his appropriate adjustments in accordance with USPAP and with the standards. And Mr. Judge Cochran found the most weight that his appraisal report was adequate and it met the test. It reduced the property from 2.7 million to around 1.5 million, but the county was trying to get it right. That's what they're trying to do. Mass appraisal versus a fee simple appraisal or single property appraisal. The issues raised by
I object to continued use of falsified information. There is no document stating that it was ever 2.7 million. Please give me a document that you continue to say that, Mr. Lee, but there is nothing to say the original value is 2.7 million. That is falsifying and misleading information, and I object to that.
All right, I understand your objection, Mr. Lee. Are you referring to an exhibit or portion of the record?
That is what's on the administrative judge's order. That was the certified value. The property record card should have it, which would be exhibit 31, I believe.
Okay,
if you want to pull up the property record card, exhibit 31 will have the certified value.
Okay, we're gonna.
They may have transposed numbers.
Sorry, I've got a lot of people talking to me all at the same time when you do it one at a time. Mr. Lee, I understand that you're saying you're referencing exhibits, including the administrative law judge's order, which I believe on page 1 noted a different value. Let me see if I can find it here, which notes a total value of $2,703,400. I will note that if I take out a calculator and put in $2,703,400 and subtract the improvement value noted on this order of $1,523,500, it does not equal the land value noted on the order. I think that's apparent. Is that right? Did I do that math right? Is that the wrong way? Sorry, excuse me.
The total value is
Mr. Pope.
stated on page 3.
We need one more person talking at the same time. So I understand I did that math wrong. I apologize for that. I'm going to refer to Mr. Russ, I guess, for a correction on that. We're looking at page 1 of this initial decision order. That's the appeal number 132016. The administrative law judges cites the Roane County Board of Equalization value the subject property for tax purposes as follows. Or, excuse me, Mr. Russ.
It is only a typographical error there. If you look at the top of page 3, it second line. That states the local board's decision. And on page 1, if you add the land value and the improved value, you come up with the $2,034,000, $2,073,400.
Yes, so we
That-
can note
that is
on
correct.
page 1 of the order, it notes a total value of $2,703,400 from the local board, and that the order is inconsistent, and that there's probably a typographical error moving the 7 and the 0, displacing them. That on page 3 of the order, in the first paragraph, he notes the local board's decision of $2,073,400. We are here because there was an objection from Mr. Hafner as to Mr. Lee's reference to the property being $2 million. Mr. Lee then stated that he was referring to several exhibits in the administrative record, and we all noted that there's an inconsistency in the initial decision order written by Judge Jerome Cochran. With that, Mr. Hafner, I'm going to overrule your objection. Mr. Lee, please continue with your argument.
Thank you. As far as the insurance, that was a exhibit that was put in on cross-examination that was obtained during the hearing. Whether or not the Judge Cochran put any weight on that exhibit or not, there's nothing in the record that he put any weight on that exhibit. His weight was placed on the MAI appraisal for Mr. New, based on the sales comparison, and there was a cost approach, but it's based simply on the sales comparison approach from that. There's nothing in the record that would distract from Judge Cochran's decision, and simply reweighing the evidence is not the purview of this commission. There was an issue raised that there was an appraisal presented on behalf of the taxpayer that was not admitted. The appraisal was not there to testify. That is why Judge Cochran did not admit that into evidence and put any weight on that. So that's the position of the Roane County Assessor. We ask that you affirm the administrative law judge's decision.
Any questions from our commission members of Mr. Lee at this time? Seeing and hearing none, Mr. Hafner, I'll give you an opportunity to make any final comments you want to the commission.
Yeah, we feel that the Mr. New's appraisal is full of errors. We were not allowed to also present, flat out lies that he made on the cost approach. But our main contention is that comparable number 1 is the most comparable. It is the closest. It is 7.4 miles away. It actually sold in May of 2019. And the property value should be based upon this comparable and not 3 that are out of county, when there are multiple comparables that we provided that the appraiser could have used that are just as similar, and there was no justifiable reason to go out of the county to come up with more comparables. And so we are requesting that comparable number 1 be used as a sole comparable to our property. It is the most similar to our property.
Any final questions from our commission members on this appeal? Hearing and seeing none, we'll otherwise enter deliberations. At this time, there'll be no more communication between the parties and the commission. The commission, if you have any questions, you can ask your counsel, Mr. Matthew Childress, located to my right. As I normally will do, I'll read some opening questions to the commission to help guide your deliberations. Did the administrative judge misapply the law cited as a case, including the law of appraisal, as applied to the evidence in this case? Did the administrative law judge act outside of the scope of his authority, and was the decision otherwise supported by substantial and material evidence? I might also maybe note it that if you find the decision is filled with such errors that the findings of fact are not substantially supported by material evidence, you need the judge to clarify any of those errors. Also would be a reason to remand to the judge with direction of what to fix. So with that, I'll hand it to the panel. One last thing. Again, reminder, your options are you can remand it to the judge for further proceedings. You can reverse parts of the decision if you find the judge acted, parts of the decision were in violation of constitutional statutory provisions. You remand it back to the judge, or you can affirm the decision on total or reverse the decision in total. You've got some pretty broad discretion of what you would like to do with this decision. With that, I will hand it over to Mr. Russ and stop talking. Mr. Russ, the floor is yours.
Thank you. Listening to the two parties and reading the decision, I find that the administrative law judge acted appropriately, and I would affirm his decision.
Mr. Osborne, I'm going to ask you just
Also-
to speak into that microphone.
I also agree with Mr. Russ's opinion of what the testimony here has indicated. I would suggest, though, that we get some kind of correction to the total value that is shown on the administrative law judge's decision of that,
You can remand it to the administrative law judge to correct errors.
for the correction. That's the only issue I've got. The values that we're discussing, I think is reasonable based upon all the documentation we've looked at, and I'd be in favor of that.
But I have a question in regard to what Mr. Osborne said. The error was just a mathematical error and probably just a swapping
Yeah, if you
numbers.
find
And so
the
so
error
a
is
typo,
not-
typo error and
If you find the error is not substantive enough to
No,
make
no,
a difference in the outcome of the appeal. then
no,
remand
absolutely
may-
not.
Then remand may be unnecessary. You can just judicially note that there was an inconsistency or a typo in that order
Exactly.
without
Okay.
even needing to correct it.
Okay, great. Thank you.
Yeah.
The only concern I have is the topographical error being corrected. And it's obvious that it is a topographical error. So I'm all for upholding the administrative judge's decision.
I'm also in agreement.
Okay. Can we have a motion, please?
Make a motion that we uphold the administrative judge's decision and that the topographical error be corrected.
And have Mr. Rod,
One thing to mention, and this was brought up earlier, but there's two typographical errors that we might want to address on page 3 where it says 1.65 million. Purchase price should be 1.165 million.
I amend to
Sorry.
okay.
fix that also.
All right, thank
Stated.
you. And Mr. Osborne, I think seconded that, but, okay, thank you. Any other discussion before we vote on this? Okay, I'll-
Is there a step?
Oh,
Can
there's
I-
no more
can I-
no more discussion between
Oh.
Mr. Hafner. Nope, no
Oh,
more discussion. I
sorry.
can answer
I
questions at the end.
I apologize. I'm sorry.
Okay, all those in favor of the motion to affirm or uphold the administrative law judge's decision with the correction of two typographical errors? Please say aye.
Aye.
Any opposed? Okay, thank you.
All right, it was all ayes, unanimous, no nays. The ayes have it. The decision of the administrative law judge has been affirmed. We'll issue a final written order within 90 days of today's hearing to the parties. A copy of today's hearing will also be publicly available on our website within 3 business days. Before we disconnect and end the meeting, Mr. Hafner, do you have any other questions of me?
Yeah, I have a question regarding the state law regarding the solar panels. That still wasn't addressed.
I'm sorry, you're going to have to consult independent legal counsel for an answer to that question.
Okay, great, thank you.
Thank you. Mr. Lee, anything else?
For the record, I could say the solar panels are not even assessed.
You can discuss that with Mr. Hafner separately.
That'd be fine. Be more than happy to.
Mr. Lee, well, I didn't hear what you said.
The solar panels have not been assessed.
All right, I'm going to end this meeting. You guys can have that conversation.